go live button, which means we're going to wait for the stream to fire up all across the fruited plains of these internets before we go ahead and get started. As you know, we multi-stream, which means we're waiting for a couple different platforms to get moving. Rumble's not working because Rumble's down, but it looks like Twitter is alive. We've got Facebook booted up. We've got YouTube, I think, is working, hopefully. Let's make sure that it is. We're starting the show a little early today, so I misscheduled it, but it looks like that's working. And we're alive on Twitch, so shout out to my Twitch friends. And that means we can rock and roll, so let's do it. Hello, my friends, and welcome back to yet another episode of Watching the Watchers Live. My name is Robert Gruler. I am a criminal defense attorney here at the R&R Law Group in the always beautiful and sunny Scottsdale, Arizona, where my team and I, over the course of many years, have represented thousands of good people facing criminal charges. And throughout our time in practice, we have seen a lot of problems with our justice system. I'm talking about misconduct involving the police. We have prosecutors behaving poorly. We've got judges not particularly interested in a little thing called justice. And it all starts with the politicians, the people at the top, the ones who write the rules and pass the laws that they expect you and me to follow, but sometimes have a little bit of difficulty doing so themselves. That's why we started this show called Watching the Watchers, so that together with your help, we can shine that big, beautiful spotlight of accountability and transparency down upon our system with the hope of finding justice. And we're grateful that you are here and with us today. We've got a lot to get into. Day 9 of the Kyle Rittenhouse trial, and the defense rests. The jury has been excused for the weekend. They're going to come back. We're going to start closing arguments and then deliberation. We've been talking about an over-under on the time for an acquittal in this case. Not to be overly presumptuous, but we're talking about a verdict over under being 2.5 hours, 2 hours and 45 minutes. That came over from John Halgren. So think about that, because we're going to be having that conversation on Monday, but not to put the cart before the horse. We got to make sure that this thing wraps up nicely. And so we've got a lot of testimony to get through today. We have Dr. John Black, who was called by the defense. He's a use of force expert, but didn't really get into much of that today. He was really brought in to talk a lot more about timing, the timing sequence of the bullets, of the rounds that were fired by Kyle Rittenhouse. And so if you remember, well, we'll get into that in a minute, but then we're going to hear from a couple other people. A guy by the name of Hernandez, Drew Hernandez, had some very interesting testimony about Rosenbaum and what he saw. And Drew actually was on the scene there, yet another witness with body camera footage and iPhone footage telling us about what happened. And so we're going to hear from him. We're going to hear about that re-racking bullet that was just sort of magically discussed but never found, because we have a Kenosha police officer, somebody who is receiving the evidence, who testified today, and so I didn't find that round that they're talking about. And so then we spent a lot of the afternoon on some really technical stuff, and it was really sort of diving into the minutia. Very important, obviously, because all of this evidence, this digital evidence, videos, photographs, are going to be submitted to the jurors, and they're going to be able to just look at all of these different exhibits and play around with them. Just go, oh, well, look at this one, and open it up and zoom in and out on it. And so they spent a lot of time hashing through these rules. When you pinch to zoom on a photograph, are you actually changing the photograph? Is the computer, through its algorithms, going to be filling in the pixels as they spread apart? And so we've got a lot to get into. If you want to be a part of the show, the place to do that is over at watchingthewatchers.locals.com, which is our home base, where we have a form that looks just like this at this website. You can use the form, submit a question. We're going to get through them in the show. Also, if you're looking for clips of the program for the Kyle Rittenhouse trial, we are now clipping a lot of these into witnesses, so you can sort of go back on the clips channel and say, who was that guy? Who was Gage Grosskreutz? What was he lying about over there? You can just go and find it right on the clips channel. Quite convenient. And of course, the questions are coming in on Locals. Super chats are also coming in from our friends on YouTube. When they come in, they look like this. They hit up on the screen just like that. And I have my screens oriented correctly so that I will not be missing them today. We've also got some new mods in the chat. Thank you for that. If you don't want that, I just threw those out there. If you don't want that, let me know and I'll undo it. But I appreciate your help today, and indefinitely into the future. Okay, so enough of that. Let's get into the meat and potatoes. Kyle Rittenhouse was in trial today. Trial day 9 of Kyle Rittenhouse's case, and we're always taking a look at the board. This has not changed. We are nearing the end of the case, so no real permutations here. Hopefully, we don't lose any more jurors. We picked up recognizing that the government called a ton of witnesses. And so this was the full smattering of everybody that they called, number of different officers. We see a number of different crew people, Corey Elijah, YouTuber, live streamer, Richard McGinnis, another reporter. They called a forensic pathologist. They called James Armstrong. And it was a lot of different individuals from sort of a wide range of people. Carrie Ann Swart, Rosenbaum's fiance. Anthony Huber's aunt was called in here, Susan Hughes. And so that was their entirety of the case. Today, we learned that the defense presented the entirety of their case. They are now done. This is what their witness list looks like. You can see it's a lot smaller, as is usually the case, a lot less investigators and police officers and all the people that the government uses to incriminate people. The defense doesn't use those people. And so here we saw that today we had testimony from these 4 people. Dr. John Black, which is an expert witness. We're going to hear that he was hired. We're going to hear how much he was paid and all of that because Binger really wanted to get into it. Then we're going to actually hear from 2 law enforcement people. James Armstrong, who we heard from in the government's case in chief. He was the forensic video person. The defense called him back because, like I said, we're going to be fighting a lot about this photograph that came from the magical drone that was delivered on the doorstep like I guess an Amazon Prime package or something, to the prosecutor's office. We're also going to hear from Brittany Bray. Brittany Bray gives us a little bit more clarity that the magical ammunition, that magical round that Kyle had to eject and then recharge his rifle, that bullet that was supposedly thrown out of there was never found. So we'll get into that. And we're going to start the day off because today is a holiday. It's Veterans Day. Quick moment to honor the veterans. Thank you for your service to this amazing country. Saying that here on this channel, but the judge also paid tribute in court today, causing a lot of people to be hyper triggered out there because this judge is maybe overly patriotic. So here is Judge Schrader today in court giving a round of applause for our veterans.
To just observe that it's Veterans Day. And any veterans in the room, on the jury or anywhere else? Well, that's unusual not to have at least somebody in here. But Dr. Black is, what branch?
Army, sir.
Okay, and I think we give a round of applause to the people who've served our country.
All right, all right, all right.
Okay, so you may proceed.
Now, very interesting thing happened. We were taking a look at the judge. Remember in this little clip here, we're taking a look at his tie, and some people were speculating, oh, what is on this tie here? He just sort of wished the veterans, happy Veterans Day. What's going on with that tie? And, early in the morning, he's a little bit tight. Things are a little bit loosened up, so he's moving around. You're like, oh, what's going on there? What's that pattern look like? A lot of tie commentary based on the ties the attorneys have been wearing lately, but we've got a lot of commentary about this judge's tie, and the afternoon came by and things loosened up a little bit. The judge's robe kind of opened up, and we got to get a glisten at this miraculous tie. And take a look at this on Veterans Day. Judge Schrader, the American flag, baby, wrapped around the chest. God bless America, Judge. And so he just plasters that tie all over the place. And he has probably maybe seen, I don't know, maybe he's looking at some of the media stories about his phone going off yesterday. God bless America goes off, and large portions of the country have meltdowns about it. I talked about that with Megyn Kelly today on her show, which was a wild experience. So go check that out. I retweeted it on Twitter. But it's an interesting thing. People are latching on to the fact that the judge was playing God Bless America on his ringtone as like, oh, he's overly biased. He's overly prejudicial. He's talking about the Constitution. And you go, hey, he's a judge. He's basing all of his rulings off the Constitution. It's kind of important that he thinks it's pretty good, since it's the founding document upon which all the courts are based. You kind of want to have a judge that has some reverence for it, I would think, in order to adhere to the rules. How do you have somebody who says those rules are terrible, but I'm going to uphold them? I mean, to my due diligence. I'm going to do my very best to execute those rules that I think are horrendous and racist and just the worst thing that's ever happened. It's kind of a disconnect there. Anyways, so let's get into the actual trial now. We have Dr. John Black. He is the first witness that was called into court today, and he was actually a little bit of a asterisk on this segment. Dr. Black his testimony was broken up into two segments, morning and afternoon, because during the cross-examination, the prosecution said, well, we need some more information from this doctor that we can review before we can continue our cross-examination. And so I'm not actually going to present it that way. I'm going to take all of the cross-examination that happened this afternoon, and we're just going to put it where it should have gone earlier this morning. And so let's jump into it. This is where Mark Richards, defense attorney for Kyle Rittenhouse, calls in Dr. Black, asks him about his credentials a little bit. Are you even qualified to be here? Here it is.
Dr. John Black to the witness stand.
Raise your right hand. Do you solemnly swear the testimony about the given this matter with the truth, the whole truth, and nothing but the truth, so help you God?
I do.
You may be seated.
Doctor, I'm going to hand you a series of documents and then ask you to testify and authenticate to them, please. Defense Exhibit 140.
Yes, sir.
And what is that?
This is the curriculum vitae of me, Annex A, that was tendered with my expert report.
And how long is that document?
43 pages, sir.
And does that include your life and professional experiences?
It includes the highlights of them, but yes, sir.
And what I want to get into is a little...
These 43 pages here, my curriculum vitae, my 43-page resume, some of the highlights. Not everything, though. There's a lot more in there. What would you like to know? So, that's kind of a big cojones expert witness coming in and just laying down, the resume. Just kind of like what we saw in the Chauvin case where the guy wrote the book on respiration. Like the guy, I think he invented lungs or something like that. Got a patent for it. He wrote the whole book on it. And so everybody goes, oh, well, he wrote the book. So I guess we can't even cross-examine him. Guess that's the rule. So kind of the same concept. Nice big appeal to authority, if you want to look at it that way. I've got all these credentials, therefore I'm highly qualified. So Kyle Rittenhouse brings him in here and they lay that down, and he is highly qualified. He talks about his military career, high rankings there, police background, 20-something years, certified to analyze video evidence, got that credential, that credential, that credential. So Dr. John Black comes in. Now, this is a little bit interesting because he actually doesn't talk almost at all about use of force or about reasonableness or any of those things. He's sort of really testifying to his analysis of the video and the timing of the gunshots, which is where most of the crux of his testimony came in today. And that's because the state... Well, it's because that was part of the defense strategy. And earlier during pretrial proceedings, they were having the Daubert hearing where they were qualifying their expert witnesses. This is a special hearing before the trial starts to say, you say you're going to use an expert witness. Why do you need them, first of all? And are they even qualified to talk about the thing that they're opining about? Are they actually experts? So in a DUI case, you need somebody to come and talk about the blood test. Who did it? How was it analyzed? Why do you need that? Well, because you got to prove that they had blood alcohol content levels over a certain legal limit. So you justify it. The person who's coming in to talk about the blood, are they really an expert? Are they qualified? Can they talk technically about these things? Got to qualify them. Here, though, they weren't qualifying the experts for the use of force stuff. That's why we didn't hear from a use of force expert in the government's case in chief. You typically hear from those people in police shootings where there is a use of force policy or protocol. Kind of don't really need that. You don't need that hierarchy of working up. The law enforcement's first step is, physical presence, being there is a deterrent. The next thing, verbal command. The next thing, a physical force. Maybe next thing, non-lethal force. Then you don't have to go through those tiers when you're talking about Kyle Rittenhouse. He's not a police officer. Maybe one day he will, but he wasn't. Just a regular citizen. And so all of that conversation about reasonableness and use of force was really not applicable here. So all of that was left out. Instead, we got a lot of conversation about the video evidence, about the sounds, and about how this all works. Now, remember, for those of you who've been around, a quick tangent, indulge me for just 1 minute. when we first started covering Rittenhouse, I mean, it had to have been like August, probably 25th, 26th of last year. Really, a big reason this show is here and the reason this channel got the momentum that it did was because people were interested in the work that I did on the Rittenhouse case. And I did exactly what he's about to explain. So for those of you who've been around for a while, rewind back your memories to those videos. And what I did is really what a lot of these investigators did in the case is they went around the internet and they downloaded all of these videos and they were assembling them. We heard from several officers that was their sole job. How'd you investigate this case? I went on Twitter and downloaded a bunch of stuff. Oh, great, so did I. But the point is, when you do some rudimentary analysis on that, even before this evidence, probably before formal probable cause statement was even released, we were taking a look at those internet videos, and you could easily throw that into just a simple video editor, break up the video so you could see frame by frame, look beneath it at a parallel audio file, and you can see the waveform. So you can see the spikes. Very easy. So that when you scrub the timeline, when you're sort of going back and forth on the timeline in the video editor, seeking forward and back in the video production suite, you're going to be looking at how the sound, the audio matches with the frame. So what you can do if you're sort of trying to piece together what happened is you can see the audio and you can say, I see a spike right here. I heard that, and I can correlate that with a frame, a frozen frame in the video file. And so that's exactly what we did on this channel. And we were able to tease out from the online videos that Zeminski, or we didn't know it was Zeminski at the time, but we were able to see that there was a spike in the audio that correlated with multiple videos where there was a flash in the image. And so you could sort of corroborate the multiple different video files and show that there was a gun that went off that matched the exact location where Kyle Rittenhouse was, because there was all sorts of banging and popping all over the place. But there was a flash and you could match it to an audio spike at that exact frame. So you knew it was coming from that person, that gun. That gun was right next to Kyle Rittenhouse. And so we were able to sort of, piece all that together a year ago before any of this stuff even came out. And now it's amazing to see it, but this is exactly what this guy is describing. This expert witness is saying, here's how I measure the distance between the shots. Here's how I was calculating the distance from that first shot to that next shot, same exact process. Frame it out and then match it, correlate it with the audio beneath it. So here is Dr. Black with that preface describing exactly that.
Allows me to, so a waveform, if you've ever seen them, is those things that sort of have the big spikes in them and this type of stuff. A gunshot, for example. A gunshot has a loud percussive noise. I listen to the thing as it's playing. I see a big spike within the waveform. I can now mark that spike and say, that's the beginning of the gunshot. I listen some more, I watch the waveform shift, there's another spike. So what it allows me to do is it allows me to see a visual representation of sound, and now I don't have to be sort of hitting the space bar or using a stopwatch to hope I'm at or around the sound. I can actually mark that sound within it. It's the same if I look at it for 2 minutes or 20 minutes, the sound still occurs in the same place.
Okay, so same process, sort of matching it up, corroborating the two, and it is pretty obvious that when you do that, you can see the time at which the bullets were fired. You can see the ejection point, or at least hear the spike in the audio. So he goes through, he details a lot of technical stuff. It's actually quite boring testimony. If I have any criticism of this, it is quite boring. They didn't have a lot of the stuff in order. They had to relabel a bunch of files, and it was kind of sloppy. It felt sloppy. It felt like they could have rehearsed this a little bit better, so it wasn't so much, well, are you talking about clip 30 or clip 20? Well, I'm talking about clip 20. Okay, well, let me pull up clip 20 because we just had to relabel everything. And so there was a lot of that. It was sort of like a lot of clerical minutia that was just quite boring. But then we get down to some meat and potatoes. We sort of get all the technical stuff out of the way. Remember that when they do that technical stuff, it's necessary. You've got to lay the foundation. There's sort of a necessity to do it, so we'll move on from there. But here, finally, we're getting to the nuts. Now we want to know, what are your conclusions? Give us some data that we can use, because you've given us all the how-to. Now we want the sausage. Here is where the prosecutor then sort of objects, saying that this new data is outside the scope. that he's not allowed to talk about this because these timings are not pertinent to what has already been allowed to be provided in court as evidence. Here is Dr. Black today in Rittenhouse trial day 9.
Understanding what this point is, this is from, if you can see on your screen, the parent file. This would be the point where friendly, friendly, friendly is heard within the soundtrack. And obviously we can play that as well. So.
Please.
Your Honor, I'm going to object. This is beyond the scope of the court's order.
Beyond the scope of the court's order, says Thomas Binger.
This is all timing.
One of those 5-minute breaks in the library.
All right, so the judge then excuses everybody.
Let's do that. Please don't talk about this.
And what is Binger talking about? Binger's talking about a prior court order saying that there were these, we've talked about these things called motions in limine, which are pretrial motions which are filed so that you can sort of narrowly tailor some of the evidence that comes in. So that you can say, well, we're not going to use the word militia on that video, which maybe they should have done. But what happened here was basically there was some conversation about what this expert can testify about. Binger is saying this expert went outside of the bounds of that, went out of bounds. Not allowed to talk about that. And he's talking specifically about the timing. And so remember, we're sort of, we can set a window time frame that really ranges any range. We could say a 5-minute time frame from when Kyle first entered the scene until he left after the shootings. You can really set any parameters you want. And so what Binger is saying is this guy is talking about something that is too far outside of the scope of that timeline. So here's his full objection in court today.
Mr. Binger.
Your Honor, the court has signed an order that specifies the scope of Dr. Black's testimony. That order indicates that he is going to be allowed to testify to what is contained on paragraph 19 of his preliminary report dated July 31st, 2021 in subsection 3A1. That subsection reads,
Page of the report, counsel.
Page 19, subsection 3A1. This pertains to the shots at Joseph Rosenbaum. That subsection reads, the 4 shots occur in approximately 1 second with the times in hundredths of a second of 0.26, 0.25, and 0.23 respectively between shots 1, 2, 3, and 4. The court has also ruled that the witness can testify as to the information contained on page 22 of his report in paragraph 4A and 4A1. That pertains to the timing of the shots in what counsel describes as the second event, where the defendant shoots at the unidentified individual, Mr. Huber and Mr. Grosskreutz. And there's some timing information there.
Okay, so it's quite boring, really, that clip. Basically, he's going through and he's saying, look, I'm looking at Dr. Black's report. He said from point A to point B, he analyzed that. From point B to point C, he analyzed that. From point 0 to point A, he analyzed that. But from point B to point 7, even though he analyzed that, we never said that that could come in. Now he's talking about points 0 to 7, which includes A, B, C, and all those D. But now it's so conflated that he's outside the scope because we didn't properly clarify this. What Binger's trying to do is to get them to just narrow that scope. Only A to B, B to C, and C to D can come in. All of those other conversations are not included because it wasn't hashed out properly in court. So Binger then says he's kind of doing the switcheroo yesterday. He was trying to sneak something in yesterday that maybe shouldn't have come in when he was questioning Kyle about that prior statement from the CVS video. Now he's sort of trying to keep something out that maybe the rules should have let in, and he's using this technicality of this report to say, well, it's not clearly delineated in here, and therefore I'm asking that the court, throw it out. So let's see where this continues on. Judge
if I
Schrader.
understand correctly, what's being pursued by the state at this point is timing sequence for the time between the friendly and the surrender to the police, which he says is a total of 400 and some, or attempted surrender to the police, which he says is a total of 4 minutes and some seconds. all of which is every second of which I think has been analyzed here in this courtroom.
Yeah, it's all been included.
That was certainly my vision at the time we discussed all this.
So he's saying that if you go through that report technically, Binger, maybe you're right. Maybe you're seeing that there is something that is, technically included or not included. But my sort of vision was that everything that is part of the timeline, that part of this sort of sequence of events would be included. Does that sound, reasonable? And so he continues on, says, judge goes off on, sort of a long soliloquy here, and then comes back and says, well, here's my inclination. I kind of like it when the jury can see more of the evidence rather than less, and so I'm inclined to let it in. Here's what Schrader said today.
Issues. We're here, and you've practiced here. You were assigned here for quite a long time, some years ago, and I think that most people would say that I'm pretty open to. I want to have the whole thing presented to whomever is finding the facts, whether it's me or whether it's the jury. I want to know as much as possible rather than try to isolate particular things and say, well, that isn't. I told the story the other day about the judge from Madison who was tormented.
Okay, so he goes off, another judge from Madison who was tormented. He goes off into a story. But you can see what he's saying. We're inclined to let the jury hear the evidence. And so we sort of pick back up with Dr. Black. He comes back out now. Testimony restarts again, and we're able to hear more about the timing between the different shots. And so here's what that sounds like. Now, the reason this is important, of course, is because Kyle Rittenhouse was in sort of a split-second decision multiple times that night and was acting, out of instinct, out of almost gut reaction training, whatever he had was happening there. But it wasn't like he was this slow, thoughtful, cunning, lying in wait, methodical murderer running around the streets of Kenosha. That was not the thing that actually happened, even though Thomas Binger has been trying to craft that narrative by creating the domino effect by showing that Rittenhouse has been lawful every step of the way. So that narrative is now going to be, I think, rebutted pretty competently by the idea that this all happened within 3/4 of a second. Here's Dr. Black.
Using your program regarding sound and video, you have determined how far apart shot 1 and shot 4 were, correct?
I have.
And that's by using the frames per second and the audiograph?
It's a combination between them both, but yes.
Okay. And if I label shot 1 as 0 time, when does shot 2 occur?
Approximately 3/4 of a second by the different timings, 0.739.
Okay. I want to get shot number 2 first.
Oh, I'm sorry, my fault. The second shot,
see that right there?
Shot 1 as a 0 point would occur 0.263 seconds after shot 1.
Okay. And what is the time between shots? What is the second and third shot?
The time between the second and third shot would be 0.247.
And the time elapsed between the third and fourth shot?
The time between the third and fourth shot would be 0.229.
And the total of those 4 shots fired by Kyle Rittenhouse occur in what amount of time?
0.739, or again, approximately 3/4 of a second.
Now,
okay, so 3/4 of a second. I mean, that's super fast, obviously. 4 shots. Now you could see there at the beginning of that clip, there was a little bit of sort of stuttering, between their conversation. Shot 1, shot 2, shot 0. And if you listen to the full sequence there was a lot of that going on. And it was very kind of difficult for even me to understand what they were talking about and when. Shot 0, was that Zeminski's shot? Or was that Rittenhouse's shot 0? Or was it shot 0? What they did is they would say shot 0 in event 2. And you say, okay, well, what's event 2? Event 2 must be Huber, and then event 3 must be Grosskreutz, right? And so they were sort of, kicking around the numbers. A lot of it was inconsequential, and I probably got the numbers wrong there. But it was a little bit just tedious. But the point here was made. 3/4 of a second, very, very fast there. And so we get a little bit more testimony from the Dr. Black here about the time between the Zeminski shot, which of course was the first shot. So, Zeminski was the shot that went off before any of Rittenhouse's rounds went off. It's that same shot that we were referencing back here 1 year ago in the video that I did specifically about that. Here is what Dr. Black says about the time between that shot and Rittenhouse's first.
How many shots or shot were heard before those first 4 shots?
Well, there's gunshots throughout the evening that I examined, but there's one clear shot that's heard prior to that.
And that occurred how many seconds before shot 0 or shot 1, which is the same shot?
So the shot, you referred to 2 shots as shot 1. So shot 0, the difference between what we're calling the first shot and then shot 0, is that correct?
Well, no. What I will refer to as the Zeminski shot. Counsel, we agree that the first shot was Mr. Zeminski? Yes. The Zeminski shot
See
to
that?
Kyle, shot 0.
The time between the Zeminski shot, as you referred to it, and the shot attributed to Kyle Rittenhouse as his first shot would be approximately about 2 3/4 seconds. Again, I can look at the exact thing if you want. I just don't have the
That's
time in
fine,
front of me.
sir.
Yeah, so it was a little bit frustrating. You can see he's a little bit frustrated here because they had to sort of relabel a bunch of stuff, and so he's calculating those numbers in his head in real time. And this is a guy who you could tell, right, is hyper, detailed. 43-page CV. My goodness, my goodness, that's a lot, right? Every single minute thing is checked and punctuated appropriately, and so he had to get in there and change a bunch of labels. And you've got Mark Richards over here. The Zeminski shot. We'll call it the Zeminski shot. Is that right? Is that okay, prosecutor? Can we just call it the Zeminski shot? And then it goes back over to Doc. He's like, all right, we're going to call it the Zeminski shot then. Is it shot 0 or shot 1? So, it's sort of the fun of 2 different styles mashing together in the courtroom. And we have a little bit more now. This is Zeminski. No, this is not Zeminski. This is Dr. Black telling us more about the jump kick man and the kick to the face, because there's a sequence of events that happens. Does Kyle shoot first and then get kicked in the face? Or did Kyle get kicked in the face and then shoot first? These 2 events were very close in time, almost on top of one another. But if you super slow-mo it, can you see which came first? He gets asked that question. Binger, of course, objects again. Here's what that sounded like.
There is what's commonly referred to as jump kick man entering in the video. Do you know who we're talking about, Doctor?
I do.
And when you analyze this video, did jump kick man kick Kyle in the face first, or the first shot go off before the kick?
I'm going to object, Your Honor. This is beyond the scope of the court's order regarding this witness's opinion.
So same objection that we heard earlier.
The jury could. You're asking him to make an identification that the jurors could make themselves?
I'm asking him, based upon his video analysis, what happened first: the kick to the face in the first gunshot in event number 2, or the gunshot in event number 2 and then the kick to the face?
Overall.
Overruled. Go ahead and ask it. So it comes over to it. He's objecting. The objection, it's beyond the scope. Mark Richards says it's not beyond the scope. We're just trying to see if he got kicked before he fired the gun. So judge says overruled. Question can come in. Here is how that sounds.
Can you ask the question again, please?
Yes. Based upon your analysis of the video and sound analysis, what occurred first: the kick to the face by jump kick man to my client, or the first gunshot?
Based on my analysis, the kick to the face occurred prior to the gunshot.
There you go.
After that was Kyle's first shot in the second event, correct?
If I'm understanding the question correctly, after the kick, the first shot in the second event occurred. That is correct.
Okay.
first shot, second event. Could have been the second event, could have been the missed shots, or Huber, could have been Grosskreutz, but they're going through this. You can see the sequence. Point there of that clip was he got kicked in the face first, which I think we all knew, but now we have an expert with 43 pages of credentials to help settle that for us. Then Binger comes out. It's cross-examination time. So we have Thomas Binger, the prosecutor, comes out and is asking him about the time from the first shot at Rosenbaum all the way to the final shot at Grosskreutz. And here is what that sounded like. How much time elapsed between all the gunshots? Do you have any idea? Here's what he said.
Observation point number 8 is the first shot that the defendant fires at Joseph Rosenbaum. Is that correct?
Yes, sir.
And observation number 26 is the final shot that the defendant fires at Mr. Grosskreutz, correct?
Also correct.
Can you tell us the amount of time that passes between the first shot, observation number 8, to Joseph Rosenbaum, and the final shot to Mr. Grosskreutz, which is observation number 26?
I can, and again, and just to make sure that I have the numbers again. We're looking for observation 26, correct? As the stop point. Is that correct, sir?
Yes.
Okay.
Observation 26.
Approximately 1 minute and 20 seconds.
1
In
minute.
that 1 minute and approximately 1 minute and 20 seconds, the defendant fires all 8 shots that we see. Is that correct?
Yes, sir.
All right. So, and that sort of matches up, right, with everything else that we were seeing. Kyle Rittenhouse has that first exchange with Rosenbaum. He is running around, and then he gets sort of assaulted by everybody else, and that's when the final chase scene that we see happens, and the final rounds are shot into Grosskreutz. So, okay, so now you can see what he's doing is the exact opposite of what Mark Richards was doing. Mark Richards went and brought this expert and said, how long was it? Point 1 to point 2, round 3, round 4. What was that? He says 3/4 of a second, 0.76 of a second. Man, that's fast, right? That's pop. Got to get that out. Now, that is to show you that Kyle Rittenhouse was acting instinctively. He was reacting, not acting. He was taking information in, making a split-second decision, and responding immediately. And so if there's a margin of error argument to be made on this, if the jurors go back and they say, that's pretty close there, I'm not so sure, I'm questioning about that, I got a little, I'm teeter-tottering to some degree. Well, if it's a split-second decision, maybe they say, well, like, it was a split-second decision, he did the best he could. And that weighs in Kyle's favor. So what Binger then wants to do is come out and do the opposite of that. Say, oh no, he had 1 minute and 20 seconds. Why did he just continue to wander around for 1 minute and 20 seconds? He could have just thrown his gun away. He could have thrown it in a bush. He could have done something else, and he didn't. That's because he wanted to kill some people. He came in from another state. He brought a gun illegally. He was driving around without a license, blah, 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 blah. Not even supposed to be on car source, curfew violation. He plays Call of Duty. Right, all of those arguments. And so the 1 minute and 20 seconds we're going to hear on closing is just a ton of time where he could have made a lot of better decisions, and he didn't, and that's why he should be convicted today. That's going to be the closing argument. I can already see it. So that's why he's expanding the scope. The more time he can elongate this thing, the better. Here is another, ridiculous question, but I want you to pay close attention to this. We're going to watch this one, I think, twice. We'll watch it first, and then we're going to watch it again. So here is Dr. Black being asked by Thomas Binger, how much money do you make for 43 pages of credentials? Here's what that sounded like.
You indicated earlier that you're being paid hourly for this. How much in total so far have you billed the defense for the work you've done in this case?
Estimated at probably a little over $9,000.
Your Honor, we asked earlier for some data that he can generate for us. I'd like to see that before I finish my examination of this witness.
No objection.
Okay, so Binger then needs some more information before he can come back and carry on his cross-examination. But it's kind of that biased question, oh, you're getting paid for your opinion. And an obvious question to that is, hey, dummy, dumb, Thomas Binger, how much are you getting paid there? And who's writing your paychecks all the time? Is it the same government that's writing the paychecks for the police, for the judge, for your assistant over here, for this building? You want to talk about payment and bias? Get the hell out of here. So, obviously that's a pretty easy response to deal with. But the other thing that you can take a look at is this fella here in the back. Now, some interesting facial expressions been going on here today. And we have this fella back here. You can see, going to give him a circle back here. He's sort of fixing his collar. And he is very interested in this question. And I was watching this and I was cracking my tail off in my office today. Watch what happens when he realizes he's in the wrong line of work. $9,000 for working on this case? Pretty good deal. Here's what he thought about it.
You indicated earlier that you're being paid hourly for this. How much in total so far have you billed the defense for the work you've done in this case?
Wait for it.
Estimated at probably
Wait for it.
a little over $9,000.
Ooh,
Honor,
that's pretty good. $9,000. Ooh, I like that number. Yeah, so that guy, a lot of those facial expressions today from that guy, if you were watching him. Very interesting character, but then he's sort of gone later in the day. You can see here. And so let me show you another clip here. This is Thomas Binger, who is continuing his line of questioning. So I think this is back in the afternoon. So yeah, so the Megadeth guy in the back, he's gone because we come back in the afternoon. They take a break. And then Binger gets the information that he needs. They come on back and they ask him questions about this. Give us some details about the image manipulation. How does this all work, Dr. Black?
With regard to this video, in the report you gave us since we last talked, it indicates here that you trimmed the video and it indicates you enhanced the levels. So you say you adjusted the contrast to 14.4 and the brightness to 175.1. Am I reading this correctly?
You are reading it correctly. However, if you take a look slightly forward in the report, these are matched estimated values post-production. In other words, I didn't capture it at the exact moment I was working on this and during the last time we talked, and I matched the levels consequently.
What do you mean you matched levels to what?
To the appearance of the video. In other words, what you're doing is you're adjusting contrast on one side of it, and if you want, I can show that to you.
No, you can just describe it.
That's fine. And you're adjusting brightness on the other. There are two slider items, so to speak.
Sure.
One slider goes up from 0 to whatever, the other goes down.
I think we've done this a lot on our own personal cell phones. What I'm wondering is, how did you arrive at those settings for contrast and brightness? What were you comparing them to, or where did you get that from?
The original
The
image.
actual video.
So you had a raw video from the source, which had a certain contrast and brightness level?
The video that was given to me, yes, sir. I had a raw video with the.
And then when you did work on that video, you adjusted the contrast and the brightness on your work to try and match the original?
No.
Okay, so so that goes on for like another 2-3 minutes. I just wanted to give you a taste of that. It's not anything interesting. It's a lot of boring nonsense. It's basically the prosecutor who's having a very difficult time understanding how sort of video manipulation works. And it's what Dr. Black is trying to explain. I'm going to show you. He actually gives us an example of this here in a minute. But quick thing I wanted to point out. So first of all, it's not really a good idea to let an expert witness who is oppositional to you, to give them the full floor and just let them go. To just let anybody who is not on your team, give them a full floor and just say, tell me how that works. Because then you can see they do exactly what he did. He just goes and goes and goes and goes and goes and goes. And they start going down this technobabble road and you just get all discombobulated. He's the expert. He's got 43 pages of this stuff under his belt. Thomas Binger doesn't. Probably a smart guy, more or less, maybe not. But he's a lawyer. He's not a forensic videographer, whatever that guy's credentials are. So you can lose control of an expert in that way, and so you got to be careful about that. So it felt to me like Binger was sort of grasping a little bit, trying to fill this thing up. Well, just tell me more about it, and you change things, right, and so on and so forth. But he did do something good when Dr. Black asked him, I can show you, I can give you an example on how I do this. He said, nope. Don't need to see it. Don't want to see you showing anything. Not going to give him the glove, right? Don't give the defendant the piece of the evidence to tell him to try it on and ask him if it fits. No, it doesn't fit. Oh, isn't that nice? So, it's one of those things where you got to be very careful about how much control you give over to the expert witness. And so Thomas Binger, to his credit, didn't do that. Now, Mark Richards, as soon as Binger was done, asked him to do that very thing. And that's what this looked like. Now, this is pretty cool. I'm going to play this out for a minute so you can see how he turns a video that you can't see anything on into something that you can clearly see. Here's how that looked.
As you sit here today, is there any clip that you could take and just show by moving the bars, color and contrast, what happens? Not color, brightness and contrast, I believe.
Yeah, I can actually.
Could you demonstrate that for the jury? Take one of the standard clips.
And you just want the idea of brightness and contrast, correct?
Correct.
Okay, so watch. It's pretty cool. I fast forward through some of this stuff. He's just giving us an example. Input A software. He's sort of telling it what it should do.
As is?
Correct.
Okay.
Input and output. It's going to do some encoding.
So
Render it.
what you can see on the screen is these two sliders up here. And I'm going to go down to a place that's got a little bit of something in it. And all I'm going to do is I'm going to slide this in that direction, and you'll notice it lightens up. If I were to keep sliding in that direction, it lightens up some more. If I wanted to get a little bit more contrast to it, and then as Mr. Binger has already described, I move them around to a place where I can get hopefully a little better understanding or clarity.
Okay, so we have him that we wrap up with that testimony, and then we're going to come back to a lot of this video evidence here shortly, because we're going to spend most of the afternoon talking to Dr. Armstrong. I'm sorry, not Dr. Police Officer Armstrong about a lot of this video footage. And so different sides are getting different documents admitted in. We had Dr. Black got a lot of other video evidence admitted in that was actually quite good. I didn't clip it here because you are watching the shots go off in ultra slow-mo, and you can see exactly, man, what's happening. It's really, really nicely done video footage, and I think it supports Kyle's case better, better than anything. But it was introduced. We can see the timing, and it's all gonna go in front of the jury, and so we'll see what they want to do with it. Our next witness here is Brittany Bray, Officer Brittany Bray. So she comes in, and she is the person who helped to gather a lot of the evidence. So she's taking a look right here at some of the exhibits that are going to be submitted also in front of the jurors. This is Mark Richards called her, a police officer, somebody who works in evidence, to the stand and asks her about this. She's taking a look. Do you recognize these things?
Yes, I'm familiar with all of them.
Okay, and what are they?
They are shell casings.
And are they all the same caliber?
Yes, sir.
And are they all the same make or brand?
Yes, they are.
And those were found in the middle of Sheridan Road?
Correct.
And did you find or log into evidence any unfired bullets at that location of that caliber and that brand?
No.
If there had been an unfired bullet matching those empty shell casings, is that something you would have taken as evidence?
Yes.
Thank you. Move those exhibits into evidence.
No.
Leave that there for the chat for a quick minute. So she kind of disproves that magic bullet theory, right? If you would have found that ejected shell casing there, then you would have categorized that. You would have logged it into evidence. We'd be looking at it right here, wouldn't you? If Kyle Rittenhouse ejected that thing, And we know that there are 8 shots because there were 8 other rounds fired. We got those accounted for. If there was an ejected shell that was unfired because he re-racked it, as Gage Grosskreutz says, alleges, you'd see that somewhere. Guess what? Nobody has seen it. So she comes in and talks about that, absolutely supports the idea that Kyle Rittenhouse, as he said, did not re-rack the weapon. And then this is the cross-examination. So Thomas Binger comes back out and says, tell me about guns, Madam Officer Brittany Bray. And he even gets rude with his own officers, people who are on his side normally. Here's what that sounded like.
Are you familiar with AR-15s?
Yes.
How are you familiar with them?
I own them. I've shot them. I've trained with them.
Have you ever had an experience where one has jammed on you?
Yes.
Can you tell us about that?
You have to clear it, usually to rack the slide back to eject the jam, whatever the round is that's jammed in there. Send it forward and another bullet would go into the chamber.
When you have to eject whatever's in the chamber, the thing that's being ejected, is that a spent shell casing or is it
Could
an
be
unfired?
either or. Could be either or.
We need to make sure we're not talking at the same time for the
Sure.
benefit of the court reporter. So, in your experience, have you ever had a situation in which you have pulled the trigger, the round has fired, but the spent shell casing did not automatically eject like it should?
Yes.
And then that process you've described would be the way of ejecting that spent shell casing?
Correct.
I have nothing further.
Okay, thanks, Binger. Thanks for thanks for working through how firearms work with her today in court. Weirdo. All right, so that was Brittany Bray, police officer, talking about evidence, going once again to support the idea that there was no re-rack. Kyle Rittenhouse was not singularly trying to execute Gage Grosskreutz without any justification, like he says. So all that took place. A lot of testimony there, as you can imagine. We get to our next witness, Drew Hernandez. First name is Frank, goes by Drew. He was there on the scene. Now, this guy's very interesting, very aggressive witness. He was somebody who was not happy with Binger, didn't sound like he was happy with his prosecution at all, gets hot, right? And we see this back and forth between the prosecutor and Mr. Hernandez, who is from Arizona, by the way. Shout out to my brother from Arizona. And let's listen in on how this testimony sounds. Here is him being sworn into court today.
I swear the testimony about to give in this matter be the whole truth and nothing but the truth, so help you God.
Yes.
You may be seated.
Sir, will you state your name and spell your last name, please?
My name is Frank Andrew Hernandez, also known as Drew Hernandez publicly. My last name, Hernandez.
Okay. And Mr. Hernandez, can you tell us a little bit of your background in terms of what you do for work?
So I'm a professional commentator on Real America's Voice. I commentate on the news, I commentate on what's in pop culture on a daily basis, and I also do on-the-ground reporting, specifically on protests and the 2020 riots.
And as it relates to the your on-the-ground kind of reporting is what I'm interested in. Were you in Kenosha on the evening of August 25th of 2020?
Yes.
And were you there to cover what was happening with the civil unrest in Kenosha?
Yes.
And were you able to do that with some type of video equipment?
I use my iPhone, and I also use a body cam. And specifically on this night, that's what I was using to document the riots.
All right, so that's good stuff there. iPhone, body camera, that's stuff that you really want if you've got a police officer involved, because you can see exactly what happened. This guy has it. He's down there on the streets running around. So we've seen a lot of footage. Now he sees stuff from his perspective, and he's a defense witness. They're calling him in to say what he saw. So that's good stuff. Now, he is here telling us a little bit more about Rosenbaum, and his testimony is pointed. He's very concise, gives us a very clear, distinct recollection of what he saw. It's not good. He's talking about Rosenbaum pushing a flaming dumpster into a car full of cops. Here's what that sounded like.
Where you saw him originally, if you can.
The first time I saw Mr. Rosenbaum was when the police were pushing the rioters back to the gas station on Sheridan, Ultimate, I believe. And Mr. Rosenbaum was pushing a flaming dumpster on fire into police vehicles that were occupied by officers and human beings.
Mr. Hernandez, I'm going to show you what has been marked as Exhibit 149. Can you identify that? Tell me what that is, a photo of?
This is a photo of the event I just described.
Okay. And does that photograph, that's a still photograph of a video that you took, is that
Yes.
right? All right. I'm going to ask that you look to your left.
Okay.
And if you can play that, can you tell me if that's what you captured?
Okay, so they go through a bunch of video footage, and I'm seeing in the chat somebody says this guy might have flown out last night here from Arizona, which is a big deal. So very interesting that he showed up. He's there, and now he's being asked about this. Did you record all of this in real time? Did you hear what you said about Rosenbaum literally pushing a flaming dumpster into a police car filled with people? Did you hear that? Did you watch that in a video on Twitter, or did you hear that? See that and hear that. Here's what he says.
Did you see what Joseph Rosenbaum was doing as he was chasing Kyle Rittenhouse?
So I was at the corner of the car source, and the first thing I did identify was that Rosenbaum was charging Kyle Rittenhouse from behind. And then as he's charging him into the car source parking lot, a firearm goes off. You can see it in the frame at the top of the car.
Can I ask you this? Stop you for a second.
Yeah.
Did you hear that real time?
Hear it and saw it in real time.
Okay, go ahead.
And as the first firearm goes off, Rosenbaum is already charging Kyle from behind, attempts to throw a bag at him, not sure what's inside of it. And Kyle is right at the corner, right there, in the car source, and turns around, and Rosenbaum is lunging towards him very clearly, and Kyle fires.
And do you see that with your eyes
Yes.
that night?
Mhm.
Okay. Your
There you go, folks. That's a strong witness right there. Rosenbaum was lunging. So now you've got multiple witnesses now. You've got McGinnis, who said that specifically. Remember, they had this entire battle about what Rosenbaum was doing. Thomas Binger really hasn't given us an alternative explanation about what happened there. I guess Rosenbaum, I keep joking about it, tripped on his shoelace, but I'd like to know if there was a reasonable explanation there. Is there a hole in the pavement or something? Did he just trip? Is that the explanation there? Because we have two people saying that's not the case. It looked like he was chasing, looked like he was lunging. We have Richard McGinnis who said that. Now we have this guy, Drew Hernandez, saying the same thing. Corroborated, and he was there. We don't need a bunch of videos to prove that claim. The guy was there. McGinnis was there. McGinnis is an alleged victim in the case, and he said the same thing. Rosenbaum was lunging, not falling. They had a big battle over the semantics on that word. So the whole thing is now being buttressed by the defense. That was a very nice clip for them to just kind of show the jurors. Rosenbaum was the provocateur here, not Rittenhouse. All right, next up, we have another clip from Drew talking about contact with Kyle. You were there all night. You got all of this video footage that we are very excited to admit to the jurors. And question for you. Did you ever see Kyle causing a ruckus? We know that a lot of people saw Rosenbaum running around, starting stuff on fire. We heard from you that he was going to throw a dumpster into a bunch of police officers. How about Kyle? Did he do anything that was overly aggressive? Was he out there acting a fool like Rosenbaum was?
Your contact with Kyle that evening was just in terms of what you observed, I'm asking. Did you observe him acting in an aggressive manner to anyone that you observed?
In no way, shape, or form. The first time I saw Kyle, he actually de-escalated a situation.
Boom.
Did you observe him at any time that evening pointing his firearm at anybody or threatening anybody with that firearm?
No.
All right, no further questions then. They wrap it up there, I believe. So they got him to come out and admit that there was no aggressive mannerisms from Kyle, nothing that was overly provocative, nothing of the sort. Actually de-escalated a situation, was putting out fires and all of that. So what we have there is Corey Chirafisi wraps up the direct exam, moves all of his videos into exhibits. So those are all going to be going in front of the jurors, and they're explained by him, right? It's his interpretation. He was there. And, you can sort of see how you can balance between the two. Video footage, yeah, it tells you a lot, but it often doesn't tell you the full story. And somebody who's there at the scene, they can tell you a lot, but probably also not the full story. And so now you've got to sort of, weigh and balance those different pieces of evidence, his direct testimony and the video corroborated by Richie McGinnis and many others, and see how they do with that. So, okay, couple other clips now. This is Drew Hernandez cross-examination with Thomas Binger saying, why did you even get an attorney in this case in the first place? I mean, if you're such a nice guy and you're such an innocent guy and all that, and you just wanted to give us this evidence, all this video footage that is so authentic and it's so complete and you're not hiding anything and we can trust it, and you're a credible guy, then why did you need to go hire a lawyer before you gave us this evidence? I mean, if you're just an independent journalist who's just posting stuff on YouTube and on Twitter, why get a lawyer? Here's how that sounded.
What you did is you took a portion of your body cam video and a portion of your cell phone video and you spliced them together.
I don't know if I would say splice, but I put them together.
That's an old-fashioned movie term from when they used to have actual film. Why did you do that?
Because it's the same exact event. Like I said, you could take a look at the body cam footage as well. You could see it as well on there.
And you're testifying here today that through your attorney, you have provided the defense and the state with that entire incident recorded on both your body cam and on your cell phone?
Yep.
But what we just saw was your editing of them together.
You guys asked for my footage, so I gave it to you.
Through your attorney?
Yes.
That's an attorney that you have out of Madison?
What's the relevance of this?
All right, Judge
Your
gets
Honor,
a little snippy.
We've had a lot of questions about other
What's
people.
the relevance of this?
In front of the jury.
I would like to know why he felt the need to retain an attorney to provide video in this case. I think it goes to bias. I think it goes to credibility. It's been asked of other witnesses.
Let's take the lunch break. Please don't talk about the case during the break.
All right, so the judge excuses everybody, and this is where things start to get a little bit dicey because Thomas Binger has already been scolded about commenting on Kyle Rittenhouse's constitutional rights, really his right to remain silent, but not gotten into his right to counsel. But that's another very closely related right that's sort of, right in that same constitutional penumbra. And so we talk about the idea that Rittenhouse, the prosecution almost crossed that line by asking Rittenhouse about that, by trying to introduce evidence that was previously precluded. Now he's kind of getting close to that. He's asking somebody else about some of their constitutionally protected rights, like getting a lawyer. And so we have a long conversation about this. And here is what ends up happening. The judge ultimately allows the question to come in, saying that it could go to bias. There's sort of this weird relationship that's going on. Apparently, the lawyer that's representing Drew Hernandez is the same firm that produced a report on a cell phone in the Rittenhouse case. So it's not, unusual that you have a big firm or you have third-party contractors who do legal services for you. So for example, here at our law firm, the government tests somebody's blood, right? They test somebody's blood. When you get pulled over in a DUI case, they draw 2 vials out. One's for them, one's for us, because we don't trust their test. And if they open up their blood vial, well, they're going to taint our test. They're going to taint our sample, and we're not going to be able to test it in its raw, authentic form. So they give us 2 vials. Now, we take that second vial, and I don't have a chem lab back here behind this corner over here where I just do blood analysis. So if we want to do a second test, we send that second test out to somebody else. And so it's a third-party person, just like a vendor, right? Just like you said, we need this blood tested. Okay, we've got a former forensic crime lab person who does that work for us. And so same type of thing happened here. Now, what the prosecution is saying is that Drew Hernandez, his lawyer, is somebody who has some sort of close proximity or might even be the same law firm that tested, I think it was the cell phone in Kyle Rittenhouse's case or made a copy of it or whatever it is. So prosecution objects. This shows there's bias. This shows their collusion. Maybe the defense is trying to buy off Drew Hernandez, and so that's why I have to start to inquire about this. Here is what happens now. Judge Schrader says, sure, ask him about it. Here is that question.
Mr. Hernandez, you had indicated that you have provided with both the defense and the state with your full footage from the night of August 25th. Is that right?
Yes.
And you did that through an attorney from a law firm from Madison, correct?
Yes.
And that's an attorney whose firm is also providing services to the defendant in this case, correct?
Today is the first time I'm hearing of this, so I don't have any bias because I just heard about this today.
Ooh.
After this incident, the shooting occurred on August 25th, 2020, you posted videos in support of the defendant after that, correct?
Can you repeat the date one more time?
After the shooting on August 25th, 2020, you posted videos on social media in support of the defendant, didn't you?
Define support.
You posted videos that you felt would help his case by showing aggressive behavior on the part of Joseph Rosenbaum, for example.
I posted the same video that is evidence today.
And in your commentary associated with that video, you made some disparaging remarks about Mr. Rosenbaum, didn't you?
What would you say is that?
Do you remember what you said?
I'd like to hear it.
Listen.
So you don't remember what you said?
I have no idea. I post on Twitter many times a day. I posted many videos. If you could specify what exactly you're talking about, I could correctly answer you.
All right, so this witness now getting a little bit squirrely. What do you mean by disparaging there, Binger? So he's getting squirrely on this. Now, Thomas Binger then is going to sort of ratchet this up a little bit. He's a prosecutor. He does not like when you talk back to him. He's used to ruling with an iron fist. He's used to just having the whole stinking system sort of catering to him. And so when he gets a squirrely witness on there, what is he going to do? Well, he's going to throw a little temper tantrum because baby Binger over here doesn't like it. And the judge is going to scold him for a very inappropriate tact with this witness. It's okay for witnesses to get squirrely, right? That's why you're a lawyer. But you can't really cross some of these lines. And he does. Judge doesn't like it.
Sir, I'm going to ask you a question under oath.
I will tell you that I don't typically permit lawyers to remind people that they're under oath. And it's happened a few times in the case here. It's not permitted. I don't think most judges do allow it. Of course, they're under oath. So it's actually a suggestion by the questioner that the witness is not being truthful. And you're welcome to argue that at the end of the trial, but don't use it as a preface to your questions, okay?
Have you ever posted anything on social media?
Ooh.
Yes.
In support of Kyle Rittenhouse?
One could argue yes.
You've also...
All right, so a lot to unpack there. Now, I'm going to ask you again, under oath, you liar. It's kind of what that's saying, isn't it? It's kind of a threat. You better answer the way that I want to, or else I might think you're lying. So the judge didn't allow him to do that, got scolded for it, as he should have. And when the judge finished his scolding, did you notice this? I'm not going to play the whole clip again, but did you notice that he didn't acknowledge the judge? The judge said, so just don't preface your question with that next time, okay? Binger didn't say, yes, Your Honor. Apologies, Your Honor. Thank you, Your Honor. He just jumped right into his next line of questioning. Oof, man, that judge, he picked that up. I'm sure of it because I picked it up and I'm sure you did too. Okay, so then we now get the objection is overruled. So the cross-examination can continue on. Here is the follow-up to that question. So there's an objection. The judge says, stop using that language. Continues on with the next line of questioning. Here it is.
My question was very simple. When that person on the roof is shining that laser pointer at you and you think that they're pointing a gun at you, that made you fear for your safety, didn't it? He didn't answer that.
Question? What did you say?
Asked and answered. He said yes.
Do you recall the question?
Yes, because I didn't want to be misidentified as a rioter.
And you were fearful for your safety at that moment, weren't you?
I'm always fearful in the midst of riots.
Sir, at that moment, when that person on the roof is pointing a laser pointer at you and you think there's a gun pointed at you, you were fearful for your safety, weren't you?
Because I didn't want to get misidentified as a rioter.
Are you able to answer that question with a yes or a no?
I will say,
Ooh.
in fairness, I think the witness has answered it now.
Fair enough. I have no further questions.
A couple.
All right. So again, right, he's getting just kind of jerky about it. Can you answer that question, yes or no? Yes, please. He just kind of, look, it's just like this long, drawn out, just whiner. Now, look, it's not that you can't get aggressive with a witness, but man, after 9 days of this, the Binger routine is starting to get old. All right, so the redirect happens. Now, the redirect that we didn't get for Kyle Rittenhouse yesterday, we now get a redirect for Drew Hernandez, miraculously. So I think it's Mark Richards, might be Corey. Let's see. They come back out. They try to rehabilitate Drew Hernandez here a little bit.
Do you believe that posting videos of what you saw was done to help Kyle?
No, because at the moment I posted all these videos on social media, I had no idea who Kyle Rittenhouse was or Joseph Rosenbaum the night of the riot.
And the purpose of posting the videos was what?
To report. I'm a journalist. I'm a reporter.
Mr. Binger had showed you a picture of or a video of the green laser thing.
Mm-hmm.
Any idea who did that?
I have no idea.
Nothing else.
All right, so he wraps up, and then I think we get a recross, and this doesn't end well. So Drew Hernandez, you can see him he's just sort of smirking at Binger, extremely irritated about the idea that he's injecting his stories or sort of manipulating the reporting that he did in order to be overly biased. So here is Binger now. This is the final recross, the final segment with Mr. Hernandez.
You say you're a journalist and a reporter?
Yes.
Earlier, you identified yourself as a professional commentator.
All the above.
Is it your practice as a journalist to interject your personal opinion into the stories you're reporting on?
No.
But you did that here.
Where?
On August 25th, a few minutes after these shootings, you posted on Twitter your opinion as to whether the defendant in your mind was right or wrong in doing what he did, correct?
No, I said apparently at the beginning of that statement.
Ooh.
What effect does that have?
It means apparently. It doesn't mean that this is 100% my opinion.
You had already jumped to a conclusion, an apparent conclusion at that moment, right?
That's what apparently means.
But
Yeah,
that's not
dummy.
what journalists do, right?
I don't know where we're headed here.
Yeah.
I'll be done. Thank you.
Yeah.
Okay, you may step down, sir.
You see his smirk there at the end? Yeah, nobody knows what the hell Binger's talking about. Judge says, I don't know where we're going here. Corey Chirifisi says, Judge, this is argumentative. That's not what journalists do, though, is it? Drew? Oh, my gosh, the guy is like, ugh. You know, it's almost like I might feel bad to beat up on Binger every day, but I don't. The guy just deserves every single ounce of it. Okay, so Drew Hernandez then wraps it up there, gives that little smirk there at the end. And so let's give some shout-out love to our brother on YouTube, Drew Hernandez. This is his channel. Go check it out. Type Drew H Live or Drew Hernandez over there. That's what it looks like, so make sure you go subscribe to him for his nice performance today in court. Love Drew Hernandez. Okay, and so we're going to pick back up now. The trial continues forward. Corey Chirifisi now calls back Mr. Armstrong. This was a police officer, somebody who was a witness that was called by the government previously to tell us about some of the video analysis that took place. And so we are wrapping up the defense case in chief. They're going to rest after we sort through this Armstrong stuff. And it's very technical. It's all about this footage that has been enhanced that came from this drone that was sort of magically airdropped on the prosecutor's door on Sunday night this past week. Trial was already well underway, and so they called in this guy, Mr. Armstrong, to come and do all of this last minute analysis on this new drone footage that was not the same FBI drone footage that we saw, not that aerial footage. It was sort of a consumer level drone that popped up on the other side of the car source that we had not seen previously. And so Armstrong comes out and talks about blowing it up. And we've already had a lot of conversations from the expert witnesses in this case about what that does. When you pinch to zoom, it's sort of blowing up the pixels, right? And now you have to fill in those pixels with other information. The judge had an interesting example today. He says, look, if I take a piece of paper and I draw a bunch of squares on it, and then I want to blow up those squares, they got to get bigger, or they got to move. Like something's got to change. Like if I expand that piece of paper, something's got to change. So how does that work, And he acknowledges that he doesn't understand technology all that well, but he's got some logical capabilities just to understand that something's got to change. If you take a pizza and spread it out across a table, you don't suddenly get a bigger pizza. You have a bunch of empty space and a bunch of unhappy people who were expecting more pizza there. So he knows that instinctively, and he's trying to wrap his head around that. So we spent a lot of time with this today. Extremely boring, extremely tedious, but important. So let's take a quick minute and see what's happening here. Here is Corey Chirafisi now bringing back out Mr. Armstrong to talk about this stuff.
Is it pixels that you expand? What do you do to make it bigger?
It's based off of the enlargement is the interpolation that is used. So with regards to this references a video that was interpolated and outputted. Are you speaking to the photo?
Yeah, speaking to photo, what number is it?
It's the 1 of 8. You want to show it to us?
Okay, so he's talking about this, right? Breaking this down, talking about pixels, talking about getting these photographs in. And the reason why these photographs are so important is because they're saying that Kyle Rittenhouse was pointing his gun at Rosenbaum previously, saying that he's sort of in an aggressive, I'm going to shoot you type of a stance. Somehow that is him, maybe having a motive. He had some reason to do this. He was trigger happy. There was a bias there. Some reason that might cause the jurors to think differently. And so now you're taking a look at that allegation that this photograph exists that might in fact be critically important and change the jurors' minds. And you want to make sure that that evidence is what it is. It's not actually changed evidence. It's not that pizza that we talk about that's spread across the coffee table that you then expand. What is filling the gaps in between the slices? What is that? Are those pixels showing Kyle Rittenhouse showing a gun? Is that empty space going to be finding him guilty because some computer algorithm somewhere just filled it in? It's a scary thought. And so that's why you have to fight over this stuff to the end. Now, this is where the questioning picks up. They're asking him specifically about this. Mr. Armstrong, can you tell us, what does the computer do? He's not a computer programmer. He doesn't know. He didn't invent these algorithms. He's just a computer tech person who works for the crime lab, who's just basically following the instructions on a piece of software. And I'm not trying to belittle the work that he does. I'm sure he's a nice guy, very competent, very intelligent, but he's not a computer programmer. He's not going to be able to come in here and say, Judge, the algorithm that I programmed is based off of this numerical code. Therefore, it's going to do X, Y, and Z. He's just sort of just following the procedures. Can't open up the can and explain how it works exactly. Here's how that sounded today.
Another interpolation type of program that you're aware of that when pixels are expanded would keep the color constant through the expansion?
I cannot speak to that.
Would you agree the more pixels that you add, the more interpolation happens?
Yes.
So the question that I have and that the argument is when you expand the photograph, you're adding pixels, but you can't tell the court what color is being added, if any.
I cannot speak to that. No, that comes down to the programming the algorithm on the software.
So the original still has colors and pixels. It's expanded. Those pixels expand. The question is, do the colors stay constant?
I do not know.
Okay, so that's kind of a big deal, right? Because if you are filling in the pixels with, let's say, blackness, well, maybe it shows that there's nothing there, and that's not something that could be mistaken for a gun because it looks like a shadow. Let's say now it's a shiny metallic object that the computer fills in the pieces between the pizza slices. It says, oh, that's a black, we're going to put a black shiny metal there, not black night darkness in that space. Well, now it looks like you've got a gun there where maybe it's not really supposed to be there. It's just the computer guessing. This guy can't tell you about that. And if their government's going to be saying that that filled in space, that interpolation, that expansion of the density between the pixels that is filled by the computer is Kyle Rittenhouse pointing a gun at Rosenbaum, that's pretty important stuff, don't you think? So this line of testimony continues. Chirafisi then makes a motion to the court and says, Judge, none of this stuff can come in. All this drone footage is inappropriate. All of this expansion is problematic. Here's why.
Judge, on that, I have a motion, but I don't have anything else to ask.
You can step down, sir.
Judge, based on his testimony, so what the state is trying to do is introduce a photograph that has been enlarged where this person, Mr. Armstrong, cannot testify that in fact colors weren't added that weren't there originally. And the photograph, I'm going to tell the court that the photograph that the state intends to offer, I believe they will be arguing, shows Mr. Rittenhouse doing something with his firearm. If it is not the same as the original and colors were added to that, that is a distortion of what in fact the original photograph was. It should not be admitted because it's not relevant if he can't testify, and there's been no appropriate foundation that in fact it should be admitted if he can't testify that it didn't add colors, that colors that originally weren't there still aren't there. And I think under the circumstances, based on the evidence that you've heard today, you should not admit those photographs because they are not what I would consider to be mirror images of what the original photograph was.
All right, so the main argument, any of the enhancements, any of the things that have been blown up should not be admitted because it's not the original. It's taking the pizza, spreading it out, and then telling everybody that there's more pizza in between those slices, but it's not more pizza. It might be, it might not be, probably is a guess between the two, and it's just a computer that's trying to figure it all out. Now, the prosecution here is going to go bananas, as you're going to hear from them, that, basically this is the same thing that they do on most of these arguments. And this type of garbage happens all the time in criminal law. It's sort of let's just trust the technology argument from the prosecutors because that's what they do. They just come up with these technology devices, these machines they call them, and then say that they work perfectly all the time. There's never any doubt about their accuracy, their precision, any of the mechanics of it. It's always in perfect working order. Every time there's maintenance done, it's perfect. It's not because there was a problem with it. It's just regular routine maintenance. I mean, I can't even tell you the nonsense that goes on with these machines. I spent 6 days in Arlington, Texas, learning about them and visiting them in a crime lab. But it's all this technological stuff that's going on, very complicated, very scientific, and they know this, and they use it to their advantage. That's why it's very important for defense attorneys to know and learn the science. Otherwise, you're going to get steamrolled by other attorneys that do, or by expert witnesses that do. So you've got to be cognizant of this. They do it all the time. I can't look, even in a DUI case, you'll see what are called peaks in a gas chromatogram. And what happens is there will be noise at the bottom of this chart. And sometimes there'll be little spikes in the noise that they don't like. So what do? They just raise the baseline. They just go into the machine, into the computer code, and they just raise the baseline. They just say, we don't like that noise. And so before they give it to the defense, they just go, oh, we're just going to raise the baseline up so it hides the noise. It's like regular practice. It happens all the time. So when you see stuff like this, this is what's going on. It's the prosecution just trying to sort of rely on standard accepted evidence because it works on your phone, because you can pinch to zoom on a map or on a photograph and zoom in on somebody's pores in their face. They're saying that this should apply in criminal court. This is not an iPhone court. This is not having lunch with somebody wanting to show them a photograph of your daughter and zooming in so you can see the pretty bows or whatever. This is a criminal court of law. The standard is beyond a reasonable doubt. If there's doubt about how this algorithm works or how the interpolation happens in a criminal case, if you have Armstrong on the stand and he can't tell you how this works because it's on the scope of his expertise, he's not a computer programmer, well then that doesn't meet the standard, does it? Sounds like there's some pretty damn good doubt about what is being filled in there. But the prosecutor is going to do this thing. Well, if we don't allow this in, well, then all of our DUI evidence won't be able to come in. Yeah, well, there's a lot of problems with that too. You want to have that conversation? Also there, buddy boy, I'm happy to have it. But they just default to this. It's our technology. It's credentialed. It's certified. They've got a bunch of letters after their name. Therefore, judge, you have to accept it. And it works just like it did here. Here's what that sounds like.
Judge, all due respect to Your Honor, I think the defense is trying to take advantage of your lack of knowledge about technology, which you've expressed. With the defense argument, you can never have an enlarged digital picture. All of Nathan, and I understand we didn't object to them, but all of Nathan DeBruin's pictures that he brought in on his own on these prints are enlarged digital images. If the defense is now trying to argue that enlarged digital images are not reliable, I mean, it's first of all hypocritical, but second of all, this is just not the age we're in. We are in an age where software is able to enlarge and do things. And yes, this image, we believe, although blurry because of the enlargement, does show, in rebuttal to Mr. Rittenhouse's testimony, does show him pointing his gun at individuals just before Mr. Rosenbaum chases him.
That's your interpretation
the defense,
of it.
This is clear in the drone video. We pointed it out in the drone video. The defendant denied it. This is an enlargement of that drone video so that we can see a better picture of it.
Yep.
This whole canard of adding pixels and changing color is a dishonest argument, and I believe the defense knows that.
Wow. Whoa. That is, that's a pretty big accusation there, buddy boy, because you heard from Mr. Armstrong. He says that when you expand it, there is interpolation happening there. So how is the defense being dishonest if the argument is based on the testimony that came from your own witness? How does that make sense? And did you hear the argument? It's exactly what I said. Judge, this is just not the age that we live in. If you listen to this ruling, then we're never going to be able to use an enlarged photograph in your courtroom again. That's not the argument. The argument here that Corey and Mark Richards sounds like they're okay with is the photographs can go in. That's not a problem. But when you expand them and you manipulate them in order to enlarge them, he said that they are blurry. The computer is filling in the gap between those pixels so that it can be enlarged. It's guessing. And you might have a computer expert who comes in here, a computer programmer, and lays the foundation for it and says, look, Rob, dummy, it's 99.9999% sure that it's going to get it right, and it's just, it's accurate, and show me 35 different algorithms and all of that stuff. If you want to do that, that's fine. Those documents can come in because now you have some foundation for them. Now you know that it's pretty accurate, but you don't, because Armstrong was just sitting in court today saying, I don't know. I don't know if it changes the color. I don't know if it adds any, I don't know what it does. I just adjust the sliders. Prosecution comes back out, not even a really coherent argument other than this is the age that we live in now. So the judge takes a look. Here's what he says. Let's see here. All right, 1 second. Let me reopen this. This presentation because the videos were not working real quick. Sometimes that happens if I have a lot of videos. Let's see here.
Their expert used a very similar software to zoom in and edit and change things, because if these things are reliable, and they are reliable, and that this is what is used by by forensic imaging, forensic scientists, it's the industry standard.
Industry standard.
So if we're going to say that no technology can be brought in, no large images can ever be brought in, that is a ridiculous standard. And we've heard from 2 experts now about how these algorithms are used and what they do. And simply because this evidence may be not beneficial to their client, and in fact show their client is lying.
What?
They're stooping to this level to try and keep it out. And to me, I think making a dishonest argument based on a number of forensic scientists that have emailed me to discuss this issue with the Apple zooming, which I think was also a very similarly, I don't want to say dishonest, but inaccurate argument. Simply trying to keep out these enlarged or cleaned up images that show that their client is lying. He pointed a gun before Joseph Rosenbaum chased him.
Oh my gosh, when I was listening to that in my office, there may have been some profanity. When I was like, what did you say? That they're stooping to some level? Your own witness told you that it adds pixels. So what are you talking about? It is changing the evidence. Look, I'm not a computer programmer. I'm not an expert forensic person. I do a lot of the video editing here. I know how to do, a lot more than most people, but I am not an expert. So let's just say that the only evidence I have to rely on is your own guy, Armstrong. Well, he says that it changes when you enlarge it, and he doesn't know how it works. So the whining from the seat of that prosecutor was just contemptuous, man. Sitting there saying the defense is stooping. This is the new age. This is the industry standard. There's no argument there. He's just ranting, and he's upset about it, calling the defense dishonest, calling Kyle Rittenhouse a liar. Right here. Now, the jury, of course, is not in the courtroom, but he's making judgments on evidence that is been adjusted by his own team. So the judge now starts talking about a response. Here's what he says. It's your burden, first of all. It's your evidence. Then he continues from there.
Wait a minute. A couple of things. Number one, this happens sometimes. Lawyers sit there during the trial and all kinds of stuff comes in and out, and there's no objection raised. And then when there is an objection raised, the party says, well, this went on before in the trial and it was admitted. And I think, okay, but there wasn't an objection. So it was never scrutinized by the court. It just came in. That's number one. Number two, you're the proponent of the evidence. You have the burden of proof. They don't have to disprove the accuracy of this. You have to prove it. Number three, the witness was just here, and when he's asked, what does it depict in terms of whether the color is going to change or to what color, he says, I don't know. Now, this is the person who is providing your information to support your claim that it is an accurate depiction. I will tell you that I totally agree with your comment about my lack of familiarity with these concepts. Although logic, I have some logical skills, and when you start adding, if I take this piece of paper and I start drawing squares on it, and I start.
Yeah, and expand the paper, then you're going to see that it needs to be filled with something. So it's the pizza analogy. So he goes through that sort of long-winded answer there, and then he sort of works it through his mind, and he just says, you know what? Let me look at it. Give me the documents. So they start giving him the documents, and he kind of gets up off the bench, and then goes down to the screen and actually just takes a look at it. He wants to see it before he makes a decision. Here's how that looked. Very interesting. So he just got done looking at it on his computer. Now he's looking at it on the monitors.
Please do it one more time, Mr. Stu.
They're playing the video on the monitor, just kind of round and around. So the judge just says, you know what? I've had enough of this. Let's just go take a look at the video right now. We're going to go down, put this puppy on in 4K, all right? Let me go see the pixels. I'm going to go count these pixels here. One by one. So he just takes his time and he's walking on over there. So we can probably talk about something else. So he doesn't say anything. He kind of just gets up and walks over. It's kind of weird. Everybody's looking at him like, "What are you doing?" Kind of a weird deal. People taking pictures. All right, so he goes over there now, sitting there with Kraus. Here's the footage. Got his pointer.
He hasn't pointed them until Mr. Rosenbaum did it again.
Saying, do it again. Kraus is saying he pointed a gun at Rosenbaum. Judge is looking at it. All right, so the judge is watching.
Run it again, please.
One more time. And guess what happens? Judge continues to watch it and then says something. See if you can make this out.
I think what I'm going to do is allow it, and the witness is going to be cross-examined in front of the jury, and they'll have to make up their own decision.
All right, so the judge then lets it in, says, I'm going to let it in, and we're going to allow the jury to make their own decision, which was not a good decision, Judge. Not a good decision at all. It's, again, changing the evidence. If you wanted to admit the original thing, okay, that's fine. But they didn't lay the foundation. Their own witness came in and said, I don't know how it works. And so the judge allowed it in. Now, why did the judge look at it and come to a conclusion about its weight? Did the judge take a look at it and said, nothing change, it's irrelevant. It doesn't change the equation at all. They can make the argument and get it admitted, but doesn't, it's not going to be any different than any of the other evidence that we admitted. And so it doesn't have, any real bearing on the ultimate case. He could be thinking something like that. Who knows what his decision is ultimately based upon. But speaking in terms of evidence, it's not good evidence. It's changed. It's manipulated. This happens all the time. I rant about this all the time with DUI cases and other types of technical data. The government just kind of makes stuff up. And they just say, it's close enough. It's science. It's close enough because the computer has some estimates and we have bell curves and we have all this different data. It's 99.6% of the time right. But then you reverse that down and you say, yeah, but the yardstick, the measuring stick that you're using to measure your stuff, that's where the problem is. So all of your measurements say that you're using a correct measuring stick, but you're not. So all your measurements have a problem with precision and accuracy, don't they? So that's where this goes. The judge ultimately ended up admitting this, and a lot of people are upset about it, I think rightfully so. So here now we're going to wrap it up. We've got the prosecution talking about rebuttal witnesses, and so they're sort of whining now that because Kyle Rittenhouse testified, he might have incriminated himself or he might have lied. And we're going to bring in some witnesses to talk about his lies. Here's what Mr. Kraus sounded like today.
Witness, we're just made aware of a couple issues with the defendant's testimony. We believe we could potentially get a witness here this afternoon to rebut it. We were just made aware of it. So we may, at the end of this, be asking to keep rebuttal open.
Till when?
Well, we're working to see if we can get a witness. It'd be a person from the Grays Lake Police Department to rebut the fact that Mr. Rittenhouse was issued a bulletproof vest by them. They indicate they did not issue him one. Also, I can't imagine we find someone, but the Arizona State or whatever university the defendant claims to be attending says he is not enrolled there and is not going to college there. I don't imagine we can get a witness for that, but we, of course, will work on that.
You can open his webpage, his student webpage. So,
Well, I'm not going to cut off their right to
yeah.
rebuttal. All right, are we ready for the jury?
Yes.
Okay.
All right, so they're going to bring out some rebuttal witnesses, and they're going to talk about a vest and the fact that Kyle is not actually in college at Arizona State University. And so Mark Richards says he is in college. We can just open up the student portal there, dum-dum, and you can see what his curriculum looks like. But all right, so call whoever you want. Kyle's a liar. He's not actually in college. So you saw what happened there. Now, something very interesting happened here in that same clip. Keep your eyes on Corey Chirafisi. Remember earlier we saw the Megadeth guy behind Thomas Binger when he was asking Dr. Black about how much money he got paid, $9,000. That guy said, "Ooh, that's pretty good. Maybe I should be an expert witness one day." But now we have another little facial expression. This one from Corey Chirafisi. Now, if you were watching the clip and you were actually listening to Mr. Krause explain why he wants to bring these pathetic rebuttal witnesses in, then you probably missed this. But it is too good for me to allow to skate by. So let's watch this one more time. This is Corey Chirafisi. He's doing, I don't know what to call this. It might be a Chirafisi bypass or a Chirafisi shuffle. I don't know what it is. Maybe you can help me with this one, but watch what Corey does here.
We're just made aware of
See that?
a couple issues.
Look at that face. One more time. One more time. Watch the bypass. This is the shuffle going right by him. Here it is. Watch his face.
Aware of a couple issues.
Oh, he's so grossed out. Look at that. He is just unhappy that he's got to squeeze by that fellow. Watch this.
We're just made aware of a couple issues.
Oh, God. Oh, God. Oh, jeez.
We're just made aware of a couple issues with the defendant's testimony.
No. Look at that. Oh, it's just the worst.
Of a couple issues with the
Okay, so enough of that. Thanks for indulging me. It's going to be the Chirafisi bypass or the Chirafisi shuffle, or it could be, I was thinking also it could be Corey Chirafisi, don't touch Misi. Something like that. I don't know what it could be, but man, he is just grossed out, as you can see. He doesn't want anything to do with it. And I think that's fair because Thomas Binger was talking about Kyle Rittenhouse's little dip and dodge. A lot of colorful language here. So the Chirafisi bypass or the shuffle, I think, is appropriate. But again, here is the rebuttal testimony from Armstrong. So now we're in rebuttal territory. So they bring out Armstrong again, and they're going to get all that drone footage admitted. Here's what that sounded like.
At this time, the defense would move into exhibit 142 and 140, and we would rest.
All right.
They're resting.
Any objection to 142 and 140?
subject to final review of 142, no.
All right, received. Did you wish to present rebuttal?
Yes, the state would call James Armstrong to the stand.
Okay, so the same guy again, and they're just going to fly through this. Okay, so we settled that issue. The video is coming in. The photographs are coming in, all 8 of them. Here is this guy. Here is this guy coming in now, laying the foundation and getting all the footage admitted.
Just to not go through every one, were they all created with standards of forensic imaging?
Yes, that is correct.
You reviewed them and you know that the ones that the state's submitting are the ones that you submitted to us?
That is correct.
At this point, I would like to move all 8 into evidence and publish 155 and 156 to the jury.
Subject to my previous objection.
All right. Well, they're admitted, subject to the cross-examination.
So can I publish them?
Not yet.
Okay.
I have no further questions.
Okay, so no further questions. I don't think Mark Richards really had much in terms of a redirect or a recross. I think it was a cross, so we kind of skipped over that. All the documents are coming in, all of those photographs. It's kind of a foregone conclusion. Once the judge made the ruling, that's it. It's coming in. So the jurors are going to see that. We'll see how consequential it is, if at all. But now we get the judge talking about closing arguments. So we're going to be wrapping up the case. The judge is going to give us a schedule in the next clip about what we can be expecting for the remainder of the trial. Of course, we've got closing arguments. We've got jury deliberation coming up. But First question, how much time do you need for closing arguments? Judge is thinking an hour and a half, and he gives us a nice little story. Here's what he says.
Maybe if you were going to confine your arguments to maybe an hour and a half apiece, is that reasonable?
Very. I'd request
Total time.
including rebuttal.
Yeah. Total time.
The state is going to need 2 hours for our primary and I'd say half an hour for rebuttal, Your Honor.
What?
You know,
Look at this judge.
I had the
Story
good
time.
fortune
Story time.
to be across the street neighbor to living across the street to the late Kenneth Grube, United States District Judge, when I was a lad.
A lad.
And Judge Grube is famous for his statement that the brain cannot absorb what the seat cannot endure.
Yes.
And if you don't like that advice, President Roosevelt, one of the renowned speakers of the 30s and 40s, when asked by his son for some advice on speaking, said, be sincere, be brief, and be seated. And
so nice little story time from Judge. He's kind of adorable, isn't he? He kind of looks, he knows it's coming. Did you see that? He's like, I can't help it. It's about to happen. Have you heard of President Roosevelt back in the 1930s and 40s? Because he did a lot of speaking and he knows what he's talking about. So he's just really, really excited when he gets to talk about that stuff. And it's kind of, look at his face. Look how happy he is. He just loves it. He's just thrilled to be there. He's just happy as hell. All right, so now we get the closing schedule. Now we get to see what's happening these next few days. Then we're going to jump into questions and super chats. Thanks for being patient. So here we have the judge talking about the next coming days.
okay, folks, the evidence is closed, and we're going to break for the weekend at this point. The lawyers and I have some work to do tomorrow and to get the case ready for you on Monday, and then I'm going to ask that you return at 9 o'clock on Monday. Even though the evidence is closed, it's still not appropriate for you to discuss anything about the case with anybody, not even with members of your household, not even with other jurors. Even if all 12 of you, all 18 of you are in the same place at the same time, you still can't talk about the case. And when you get back on Monday, you can't talk about the case until you've heard my final instructions regarding our law, which will take, I hope, less than an hour. I think that will be true. I think that probably closer to 45 minutes or even a little less maybe. And then we will hear the arguments of the attorneys, and they have graciously agreed that they will not exceed 2.5 hours in duration each, and may be less than that. And so it'll take a good share of Monday. And then the case will be put, well, then the procedure will be that we'll use that tumbler over there, and we'll draw out names of as many jurors as are necessary to get down to 12. And then that'll be our jury that will go into deliberation. And then what happens after that is up to you folks. Any questions about this at all? We're in the final stretch.
Final stretch.
Please follow the instructions. And don't read, watch, or listen to any account of the trial. And enjoy the weekend, and have a wonderful evening.
All right, and that's it, folks. So the judge is going to call the attorneys back tomorrow. They are going to prepare the jury instructions. There may be some final, tweaks there. Probably a lot is going to go into that. Don't know if that's going to be broadcast or what, but we'll see. And it's going to come back on Monday for closing arguments. So 2.5 hours for each side. I guess, honestly, I doubt the defense uses even a full hour of it. They're going to come out, don't really need to play much videos, waste a lot of time there. Self-defense, self-defense, self-defense. Justified, justified, justifies. Objectively reasonable, objectively reasonable, objectively reasonable. And that's going to be the crux of it. Pretty simple, not going to want to waste a jury's time. The government, of course, is going to go through every stinking video one after another and just show you Murder, 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 murder. Could have done a bunch of other stuff. He could have, made a different decision at this one, a different decision at that one, and so on and so forth. And he's going to really just draw this puppy out because that's been the strategy the entire time. Mark Richards, everybody wants to show you ultra compressed, ultra high stressful situation. Totally reasonable to act the way that he did. Binger, the opposite of that. This thing is orchestrated long. He was thinking through this, repeatedly breaking the law, bending the rules, and causing mayhem in his wake. And so he's going to probably use every ounce of that 2.5 hours, and hopefully the jury punishes him for that. So that was the trial. The government rested earlier this week. The defense rested today. Let's see what you have to say about it from our friends over at watchingthewatchers.locals.com, where we'll jump into some questions and then we'll get over to those super chats on YouTube. I appreciate everybody hanging in there with us. First question came in from Cora. Says, it was heartbreaking to me when Schroeder approved of the state's interpretation of the photo. It is singularly disgusting when adults bully an 18-year-old, and that's exactly what Binger is doing. Someone please update the grinder. Appreciate your show, Rob. Merci beaucoup. Apologies for the foul imagery. That's from Cora. It's all right. I read it in my mind, but I censored it for everybody else because they don't need to suffer like we have, you and I. Orgal says, as a computer graphics expert, I was taken aback by the lack of understanding by these experts, so-called, especially the governments. The algorithms mentioned are well known. I've implemented many of them myself. Standard algos such as nearest neighbor, bilinear, bicubic are so well understood, you do not have to be the one writing them in the software to comment on what they do. Of the three, only the nearest neighbor algorithm doesn't, quote, add color. However, adjusting contrast and brightness changes the color depending on how color is defined. That's from Ogral. Well, thank you for that, Ogral. That's some very detailed stuff. And I agree with you that it sounded like most of them didn't know what they were talking about. LT13 says, I heard Krause say the police were going to say that they didn't give him the vest and that he is not enrolled in college and then went into the pixels. What the heck? Yeah, so, we'll see if they can actually move forward with any of that. I'm guessing that they're probably not going to waste their time. Those were nonsense issues, but we'll see. John Delar says, the Biden admin is chiming in on the trial. If he's found guilty for some reason, can the defense use that for the appeal? We kind of had that issue with Chauvin, right? And I think Chauvin's going to use that in his argument, saying that there was undue pressure by other people in the political realm that may have been something that was consequential for the jurors. In other words, it was tampering with the jury to some degree. So if I haven't seen it, I haven't seen what they're talking about the trial, but they did some of that with Chauvin. Although I think with Chauvin, weren't they already deliberating at the time? I don't know. English Dave says, do you think Kyle is more or less likely to be found guilty now that the defense is closed? I think you had 90% sure he'd be found not guilty. Is it the same now? Did I say that? That's pretty high, but I think so. I think it is. I don't think that anything has really changed. I think that the facts continue to support the defense. I do think it is messier though now. Honestly, I think that the defense shouldn't have called Kyle, if I had to be honest about it. I don't think that it added anything that we were already missing. I think the jury would have filled it in favorably to Kyle. And I think now you sort of risk, honestly, confusing the jury with all sorts of different issues about all sorts of, things Kyle said or didn't say or did or didn't do, that the jury would have filled in by default in his favor. Now they've got to think about it, which is, probably not something that tips the scales at all, but something that has the risk of confusing the issues, which is a big concern. Okay, Twitch direct message. Okay, cool. Yeah, okay, so somebody sent me, so I got to figure out Twitch. I got to learn that platform, which sounds like so boomer, but it's true. D. Delsby says, I don't think the defense called Armstrong back. It was on the prosecutor's rebuttal that he was brought in. But the fighting of the evidence before that happened, that upset me. Armstrong has no idea what his manipulation of the photo does. He shouldn't have been able to do anything to bring that evidence in my opinion. I think the defense really explained 100% the problem with the evidence that was presented from Armstrong. Yeah, it's not about, look, the evidence might be great, might be perfect. I can't speak to bilinear algorithms. I don't know. But the point is, you're in a court of law. You don't take that on face value. And especially when your witness says, I can't explain it. I don't know how it works. You've got to have a little bit higher standards there. Also, another one from Jeremy Cash says, Rob, if the prosecution already rested his case, doesn't that mean he can't add any new evidence or change his approach? Can you clarify what this means again? Yeah, it means you're done. Yeah. Yeah, you're done. You can't start recalling witnesses, and unless there's some sort of extraordinary circumstance like, I can't even think of anything in this case. But yeah, it's over. It means both sides are done. We're going to start moving into the next phase of the case. LT13 says, Jack Posobiec says the photo shows Kyle is a lefty now. Can't verify because I can't see anything in that picture. Yeah, so it's hard to see what is actually being submitted to the jurors because a lot of this we haven't seen. La Medic says, wow, you on Megyn Kelly and Rakeda on Glenn Beck, my favorite YouTubers getting famous. I saw that Glenn Beck had Rakeda on. I can't wait to listen to that earlier. Super cool. Congratulations to Nick on that. Let's see. La Medic says, how was the use of force expert diminished to computer analysis? So they settled that during pretrial. How was the prosecution able to get that concession from the defense? Also, did you think that the defense use of expert witness was effective? Not ideally. I mean, it wasn't ideal. There was a lot of back and forth. There was a lot of problematic, technical difficulties when they were talking about some of the specifics of it. But I don't think that it was anything that was ineffective. It just wasn't anything that added anything that was a home run. Okay, it's Jake from Oxford says, a few quick fires from yesterday, if you don't mind. Love your behind-the-scenes outlook on all this. I never would have picked up how the defense did not even look at Kyle after his testimony. Do you think this may be because of Kyle possibly telling them he did want to get on the stand against their wishes? Yes, I do. I think that Kyle probably overrode them, if I can be honest about it. I say we make a square pool board, let everyone buy a block of time in regards to deliberation. I love the idea of it going to charity, also in for $20. Amazing. This is my last cordial message. We are now back to mortal enemies. It's Jake from Oxford. Okay, so, well, I appreciate that, Jake. It was nice having that, the pleasantries between us, but you are from Oxford, which means you're way better than me. And so you don't have to be nice to me because I am just peasant civilian trash who is sort of being manipulated around by your global order people. So, but anyways, well, that was nice. Very nice comment. Yeah. And we're going to do an over under, I think for sure, donations over to ericshouse.org on deliberation. Rob Emery says, why did we have 6 hours of questions about colors added to videos? I know it was really bland and boring, but it was important because if the colors and the pixels that were added to the video show Kyle Rittenhouse with a gun and a sign saying, I'm here killing Rosenbaum, right? Then that is pretty bad evidence to put in front of the jury. Jeremy Matrita says, Rob, after watching so many trials lately, there's no way I could stand to be a trial lawyer. I know Binger doesn't represent all lawyers, but he certainly behaves like the stereotypical lawyer that doesn't argue with logic, but attempts to argue against all logic and reason. Makes me sick. Binger is a special one, no doubt about that. Good to see you, Jeremy. We have Kincaid says, Rob, how do you handle those situations where the opposing team challenges things like the timing of audio versus video timelines? Binger is splitting hairs, and I'm sorry I cannot understand how Lady Justice would ever condone such behavior. I'm thankful for Judge Werthers. Additionally, would you, if possible, have Black counter the prosecution's expert witness? Will the defense have a chance to do so? Finally, you get a feeling the judge was just moments away from calling the whole thing? It's always solo, impat tentor, Bingertine. Okay, so that's from Kincaid. A lot of questions there. Let's see here. So we saw what the defense did with the expert witness. I don't think the judge was going to call the whole thing. He's getting very frustrated and irritated, but I don't think that he is going to, take it away from the jury. He's going to want to do that. And yeah, Binger is splitting hairs, and it's really obnoxious, and I think he's probably going to suffer some consequences for that. You're hearing what the rest of us are hearing, and it is sort of painful. Law Medic says, I think that Binger's question to Dr. Black made to the defense case did not hurt it. So another perspective. Thanks, Law Medic. Let's see. Hand of Nod says, long comment says, is it normal for the prosecutor to convert a spoken court order into revised text? No. It seems apparent Binger was very clever to point the duplicitous in limiting Black's testimony. Today was the best chance for the defense to put together the package. They failed. The signal to noise ratio was way wrong. Why on earth is there not a single composite presentation that assembles the best footage? How many dollars are burning on either side of the aisle? Is the quality of preparation shown by either team par for capital offense cases, or was this 2 weeks of clown shows broken by episodes of competence? Particularly during yesterday's cross, there was an exchange where Binger sounded a little like a disappointed father. You shouldn't have been there. Is Binger human? Does he understand the price for his ego is humans' life, all the potential therein? Are these DAs moral monsters or suffering from severe cognitive dissonance? At the close, I'm very concerned it comes down to jury selection. Robert Barnes claimed that people who tend to think one shouldn't have been present that evening tend to lead towards conviction. It doesn't make sense, but it's awfully popular and reinforced by Twitter and the mainstream media. Nice comment there from Hand of Nod, and I appreciate that. All right, let's see what else we've got. Another one here is coming in from It's Jake from Oxford. Rob, you're approaching the prosecution the wrong way. Says Littlefinger wasn't having difficulty understanding video enhancement. He was getting notes on how to improve his video enhancement. It's Jake from Oxford. Thank you, It's Jake. All right, let's jump over to YouTube because I see a lot of super chats coming in, and I appreciate every one of them. Thank you so much. Dapper Dave started us off, says, the judge allowed the picture because he did not want to set a precedent decision on expanding, enhancing photos and videos for future cases. Thoughts? I think it was a little bit of a steamroll. He just probably thought that, might have looked at it, found it to be more or less inconsequential, maybe thought we were arguing about a bunch of nothing, but yeah, doesn't want the government to come back and say, you threw out enlarged evidence previously, and now you have set precedent in your courtroom so that any enlarged evidence can never come in. But I disagree with the judge's ruling. I don't think that was a good one. Frank Sherratt says, hi, Rob. Loved you on Megyn Kelly today. I've been here since the beginning, and it was so cool to hear you on her show. Well, Frankie, it was cool to do it. I mean, I was just like, I got an email yesterday, and what? Megyn Kelly? For real? Anyway, and it worked out. It was like a whole thing that, it was a whole experience for me. It was a lot of fun. I learned a ton. And I'm glad that you enjoyed it. Hopefully I didn't botch anything too badly. The God Faber says, is it common for clarified videos and photos to be admitted into evidence? So yes, it can be, and no, it can't be. It sort of depends. You heard one version of this. I would say that probably the default is that, yeah, the governments typically are submitting evidence that has been adjusted, and it comes in pretty regularly. Seems like he's saying, hey, here's the knife used in the murder. It had some blood on it, so we added more so you could see it better. It's a great comment. I like that. That's even better than the pizza analogy, isn't it? Well, it's like we think it's your blood, but we're going to add a bunch more blood that's yours, but we don't know it's yours. It's a good analogy, though. Paul Barras says, I've not heard any of the legal pundits address a very key issue. Juries are more emotional than logical. Kenosha is very red town politically. Your thoughts on this? So if Kenosha is very red, I think that they would be in opposition to any case that sort of jeopardizes gun rights, jeopardizes self-defense. Those favor Kyle. I think they would also be sort of against BLM protests or riots, naturally speaking, right? Because I think most people are in general, and most people don't want to see their cities burned to the ground. So all of that, I think, supports Rittenhouse if they fall in that category. Hosid says, did you see the interview of Gage done by the GMA? I think just snippets of that one. I think that's where he looks like, like a wreck in that video. He may have just gotten out of the hospital. I don't know. Graham Pinkston says you're not on Rumble, and your Rumble link is 404. I posted that on my Twitter timeline. Apologies for that. Not my fault, though. I tried to schedule it on Rumble today, and they were having a technical error. So I posted on Twitter that Rumble was just not going to be live today, unfortunately. All right, and so we've got Ronnie Cole says, I support the wrenches. Love it, Ronnie. So do I. Looking like it's a lot more peaceful over there. I appreciate that. Thank you for all the help, everybody. BW85 says, I was surprised the use of force expert wasn't asked about the reality of use of force. Kind of disappointed. I don't disagree with you there, BW85. He actually, this was settled before the trial started. The defense didn't bring a use of force expert in. The government didn't need that. We're not talking about a police officer where you have all these use of force policies. We're talking about sort of vanilla self-defense rules. And so that's why it just wasn't really necessary to get into any of those issues, even though it would have been very interesting testimony. Let's see. G Hawk says, with this trial, how this trial has gone, how would you perceive a quick jury deliberation? Good question. Would a length like the Chauvin trial potentially signal a guilty verdict? Keep up the great work, Robert. So I think a quick jury deliberation is a good thing for Rittenhouse. I think that if it's a long jury deliberation, that means they're watching the videos. They're watching the videos over and over and over. They're talking about them. They're scrubbing forward and backwards. And that is it's not a good thing. That means they're thinking about it. It's not obvious. Josh, oh my gosh, says Robert, Exodus 22:2, Luke 22:35 through 39, 1 Samuel 25:13, 1 Samuel are just a few passages in the Bible that express the right to bear arms and self-defense. Thank you for those. Exodus 22:2, Luke 22:35 through 39, 1 Samuel 25:13. Chris Anchondo says, holy ish, Rob. Get cherry picking these clips. They're all been great views. I trust your perspective on this trial more than anyone else, let alone the fake news. LGB. That's from Chris Anchondo. Thank you for that, Chris. I appreciate you being here. Jacob says, what do you think the defense do to prepare Kyle for yesterday's testimony? So they probably had a lot of conversations about it, and I would hope, practice with him. Had somebody play the prosecutor and ask him those questions, specifically sit him down. So you intended to kill Rosenbaum, didn't you? I guess I did because I shot him. No, don't say that. Say, I intended to stop him. How about that? That's a little bit better, right? So not, coaching him, but coaching him, not communicating to him what to say, but helping him say it in a way that is more legally palpable. Jacob says, no, got that one. KPZ1234 says, Binger is planning to bore the jury to death in order to get to retry the case. Well, he's succeeding because it is awful. Brad Bauer says, what could Finger possibly do during closing to get his mistrial? If he does something during that time and it is a mistrial, I guess I would bet that it goes with prejudice. Eddie Oliver says, Rob, if you find my bloated, naked corpse hanging from a shower, it was actually suicide because I was so bored from today's testimony. Well, don't do that, Eddie Oliver. We want you here with us for a long time, but I understand it was painful. Joe Calcagno says, is it odd that the officers testifying from the state were in uniform, but Officer Bray was not in uniform? You only play the part when you're working for your team. If you're working for the other guy, well, you don't want to help them, so you just come in your pajamas. Jeremy Rowe says, I would definitely let Officer Bray arrest me. Yeah, she's a nice-looking woman. Eddie Oliver says, anyone familiar with the AR platform knows Kyle didn't re-rack. You have to take your hand off the trigger to do that. Also, if I get arrested for stalking Officer Bear, will you represent me? We can't talk legal advice on this channel there, Eddie Oliver, but you know who to call. We've got Sach says, hey, Rob, it's been a while since I've been able to catch a live show. Welcome back, Sach. Good to see you, my friend. I remember you. Says, I find that the average person only knows about the crap the media spews and Kyle crying on the stand. Very sad. It is because they're feeling like the narrative is escaping from them. And so now they have sour grapes. They get very mad. When Joe Rogan survives COVID using, certain things, they get very upset about that. And so they call it other things. And they just like to kind of twist the knife a little bit. Sour grapes. So you're going to see a lot of that. Good to see you, Sach. Welcome back. Glad you joined us. Robert M. with a nice donation. Thank you, Robert M. Daniel Henry says, just sub to the channel. No offense intended, but Robert's all the eye candy of Legal Eagle with none of the BS. Loving the complete package. That should be our new tagline. Well, thank you, Daniel, for that. That's a very nice comment. Legal Eagle, did you see the meme that I posted on Twitter where they had him as the Joker? I didn't say it. Somebody else did, but it's a very funny meme. I posted that on my timeline, and thank you for that, Daniel. Cuomo's Revenge says, remember what I said tech ruses? I do remember that. I joined locals saying that the government was going to try to overly techify the whole thing to fabricate some evidence and get it admitted. Looks like that might be happening. Mimer82 says, observing from the UK, the whole thing is very interesting. That image thing seems like such a hole for poor verdicts on bad images. Yeah, because it might even not be the actual original image. Daniel Henry also says, I am a software engineer with graphics programming experience. I can tell you for a fact that bicubic interpolation absolutely does add pixels that are not there. It does this by means of distance-weighted color averaging. So there you go. Daniel Henry with the assist on the interpolation question. And it makes total sense because it's the same pizza analogy. Thank you for that, Daniel. Jay says, nice job, Rob. Well, thank you, Jay. It's a very nice super chat. Sach says, sounds like a voting machine, LOL. Corey Corey chair of feces. Oh, well, that's kind of rude to Corey, isn't it? I was saying it was the Corey bypass. We have another one from Sach says, if you remember, back in 2020, some people were adjusting DPI settings to manipulate signatures on ballots. Same concept, just manipulating the pixels. I do remember that. Armand Tan says, can't believe no one mentioned blur or reflection. Also distance. You lose detail and color information. I've been on Photoshop for 20 years. John, thank you for that, Armand. I agree with you. John Paul McMahon says, what about the prosecutor's request for the close-up of Kyle not shooting until drawn on? Did the prosecutor ask for that? I mean, some of the video footage that we saw from Dr. Black did get admitted, and that shows the shots in super slow-mo in, high quality footage. So they may get that even if it's not formally admitted as such. Deke Artie says, this has got to be the biggest of slime balls I've ever seen on the prosecutor's side. What's your opinion on this? Not a fan of Binger. If you're new to the channel, obviously never have been. Ever since the very beginning of this thing, Binger has had that smarmy prosecutor feel. And this is not out of the ordinary, okay? This is just the first time that a lot of people in this country are exposed to this. But you see two peas in a pod in this trial, don't you? You have James Krause and you have Thomas Binger here. Both of these guys doing a bunch of underhanded stuff, repeatedly scolded by the judges, acting improperly on many different issues. And this is not an aberration. I know it hurts to hear this, but this is happening in your hometown, in your local prosecutor's offices. These types of people are all over the place. If there's anything Thomas Binger is done for justice in this country, it's exposing himself to all of us so we can see how much this garbage goes on a regular basis. And I mean that. I thank you, Thomas Binger, for your service to this country. Thank you for showing us that this is how you handle a case. Now, many people, 5,000 people here right now, 70,000 people on Ricada stream, many thousands more from all of the replays, all get to see you doing what you did to Kyle, to every single witness that was brought before the court, and it was gross behavior. That's my opinion on that, Deke. We have Michael Smith says, I think when the Young Turks has stated it was self-defense, it means Kyle is good. We know how hard-headed they are about not seeing the truth. And we got a few more of these before we jump back and finish over on locals. We've got Reese Saxon says, at what point are you allowed to defend yourself with deadly force? Some are trying to argue that he was not in being harmed because he was being chased. So certainly, but a chase leads to being caught, right? Which is the natural consequence of a chase. And so you don't have to wait until you're actually being killed to defend yourself. If you're a reasonable person and it's objectively reasonable that right then and there you felt like your life was in danger, self-defense. If that's reasonable, you can use it. And so I think that's the case that Kyle and his team have made. We have another one from Not Applicable says, the whole trial seems like a sham. Justice is a myth. So I think that the entire prosecution was, no question. Dave with a nice donation. Thank you, Dave. Diane McNamara also with a donation. Very nice one. Thank you, Diane. Appreciate you there. Also with another question says, if Kyle should have kept running, if he was in danger, shouldn't have Rosenbaum and Grosskreutz and Huber all done the same thing instead of running towards Kyle? Very interesting. We also have another one from Valentino G says, I saw the photo, waited a full minute expecting it to come into focus. Jury's going to look at it and think, what the bleep am I looking at here? Yeah, they've got so much digital evidence to look at. We'll see if any of it really adjusts their perspective. Charles Hammond Jr. says, question, when the defense initially raised its motion for a mistrial with prejudice, they sounded like they quoted a statute or guideline. I think they did. I think what happened was Corey Chirafisi went out and somebody from his office or his legal assistant there, I think they pulled up a case and they actually brought out two elements about what would justify the judge granting a motion for dismissal with prejudice. And that would be basically the court would have to have a finding that what Binger was doing with some of those constitutional problematic questions that he was getting after, if that was intentional to cause a mistrial, then the judge can dismiss the case with prejudice. Why? Because the prosecutor is trying to cause a mistrial. They're trying to break a rule intentionally because they know if this goes to the jury as it stands, they're going to lose. The jury's going to come back and acquit Kyle Rittenhouse. They don't want that to happen. So they'd rather throw the game than finish it because they get another game. And if the judge makes that finding and says, I think that that's what they're doing, then he can take that chance at another game away from them and take it away from the jurors for them acting so reprehensibly. That would be a sanction that the judge might be able to impose. Couple other ones. Hosid says, GMA posted a new video about Gage today. Post testimony got 177 likes and 7.1 thousand dislikes. Outstanding. I'm going to have to watch that. I have not seen that. I think somebody else was asking me about that. Sach said, hashtag Chirafisi bypass. Beth, I like it. Beth Coddington says, hey, Robert, so brokenhearted I missed you on Megyn Kelly. It gives me something to look forward to. Did catch the trial today. Decided to watch ice melt for a while to liven things up after I finished my wine. Made it more interesting. I'm good. I'm glad you did that, Beth. It was, paint dry. Since you've already done watching ice melt, you could watch paint dry, maybe during closings, during his closing argument, or you could watch grass grow. Either one of those might be another good suggestion just to keep those going. Hope the wine hit the spot there, Beth. Thanks for that lovely support. As always, I appreciate it. Alex6 is here, says, as a future law student, this is interesting to me. However, the court almost seems like a joke. The prosecution is badgering witnesses at this point. Alex6, I think what you're going to experience when you start going around other courts, depending on what metro area you're in, is that this court is a little bit looser than some of the other courts. There really aren't many courts that are run like this in Arizona. Some of them are, but most of them are a lot more formulaic, a lot less jovial to some degree, like you see elsewhere. So you're right to recognize a little bit of a mismatch there. 3.14 says nice round number for a well-rounded stream, and that is pi, right? 3.14157, something like that. Thank you for that, Mandrake. RK says Twitter mob is talking about recalling this judge like they recalled Aaron Persky in Berkeley. Is that a serious threat or nonsense? I mean, not before they get a verdict in this case. Maybe they're mad at him after the fact. If they are, good Lord. Have you seen the Kyle Rittenhouse sort of force of people out there? This judge will get reelected in no time. He'll run for office again if it's an election type of a state. He'll start a campaign fund, and what do you'll see? $10 million in there for the judge? He'll be all right. Let's see. Brian Paul says another one. Do you think Kyle will win or lose? And what do you think the most important points for the defense to make before the jury goes into deliberation? So self-defense, self-defense, self-defense. I think that the theme that they started with during the opening was, Kyle was trying to help. He was a young man who was trying to be a hero to some degree. And we saw a lot of that. We saw he was providing medical care. We saw that many people were saying he was de-escalating situations. Came out here, faced the jurors, gave you his testimony, told you what he was thinking and feeling. And it was self-defense, objectively reasonable at every turn, every single instance, objectively reasonable self-defense. And that protection expands, covers the reckless endangerment charges, even make an argument on the weapons charge, that it wasn't technically in violation of the law because he was going to be having his friend hold on to it until he turned 18, right? All of those arguments. But it's a good question. And it's probably going to be short, 45 minutes, an hour, maybe. I really doubt it goes a full 2 hours or 2.5 hours. And those were great super chats over from watchingthewatchers.locals.com. And let's go back over, those were from YouTube. Now we're going back over to watchingthewatchers.locals.com. Robbie McCann says, will the prosecution ever realize that aha moment will never happen? Probably not. These people sort of seem like they've kind of deluded themselves into thinking this is a slam dunk case, and it isn't. Kincaid says, I may have missed it. However, where are the experts hammering in concepts like emotional states and reactions of individuals in these types of situations? I'm hopeful the jury has pondered such considerations. Should I be? So I think what you're talking about is sort of, what was Kyle experiencing mentally at that moment in time, which is all, that could be relevant, but probably not. It's sort of about his action then and there and whether it was justified. I get your point, Kincaid. I get it. Former LEO says, would the video that Black analyzed be able to be brought in at close? Because I believe the jury has never seen a real-time depiction of the events. Probably. Yeah, I think so. I think all of that was admitted and published, so I'm sure he could use it. La Medic also says, why would a use of force expert not be needed in this case? You would think his vast knowledge would and could be important. So use of force experts are typically dealing with use of force policies. Sort of at what level should a police officer escalate the use of force, from a verbal command to a physical stopping to less than lethal force to lethal force. All these different hierarchical analyses happen between each different level, and here you kind of don't need that, right? Kyle Rittenhouse is just an everyday citizen. If you could say that a 17-year-old kid in that position could have used it, that's the standard. And that's for a jury to decide. They don't need to hear all sorts of, different policies and things like that. K-Cell says, the only reason Weirdo Binger had questions for Officer Bray is so he could speak to a beautiful woman. That's true. Officer Bray, where do you like to have dinner? Rational Gay says, why didn't they ask Officer Brittany Bray if there would be any evidence on the casing if a spent casing had gotten jammed or remained in the chamber, like a crease on the shell or multiple extractor marks? If the trigger was pulled with the spent casing still in the chamber, wouldn't there be 2 hammer indentations on the primer? Yes, but it also would have had to come out, right? The bullet would have had to come out. So, because he shot Grosskreutz right after the fact. So something would have had to come out of there. And she's saying we didn't find that. We only recovered those 8 bullets that you saw. So it's just a missing magical bullet. It's Jake from Oxford says, hey buddy, since we're such great friends, I'll hook you up one time. You're welcome. Now let me know. Let me talk. We do not need to both talk at the same time. Yeah, you figure out how to do that. Now, let me tap into the live feed of the judge's desk right now. Judge Schroeder, does the defense have any last comments? Mark Richards, Your Honor, the defense would like to rest. We can in no way defend Mr. Rittenhouse any better than the prosecution has done. Also, the defense is concerned that Mr. Krause may begin bullying another special needs person. It's Jake from Oxford who's giving us, who got us tapped in to the court feed. Briggs 57 says, on the manipulated video, the enhanced drone video that the prosecution purports to show, Mr. Rittenhouse pointing his rifle at Rosenbaum while the Duramax is problematic for the prosecution, as explained below. If the black space a rifle, it would show Kyle shouldering it left-handed, not right-handed like the other pictures. This is unlikely for a few reasons. One, first, his 2-point sling setup is not conducive to shouldering on the non-dominant side. Secondly, unconsciously switching from the dominant to non-dominant side requires a bit of training and practice. We're talking at least a 2-day course followed by repetitive practice, at least weekly for a couple of months. Third, although fighting around obstruction-like vehicles is certainly a great illustration of the utility of being able to run a rifle ambidextrous, the positions of Kyle and Rosenbaum relative to the vehicles makes a right-hand shoulder the better choice. Well, that sounds like Briggs knows what he's talking about, doesn't he? Thank you for that, Briggs. I mean, that's very clear. Sounds like the image would show that Rittenhouse's gun was on the other shoulder. The likelihood that he'd have the capable skill set to make that adjustment in the middle of, was sort of, a firefight. Seems like it is maybe a little bit too much. Boneless Ravioli says, how on earth was the interpolation's expert testimony satisfactory? Wasn't his purpose to assure everyone the interpolation of the blown up image was totally reliable? You would think so. Yeah, and the judge just let it in anyways. He said the opposite of that. Says, I don't know what's going on. Watcher45 says, just want to wish you and your team a very happy Thanksgiving. I am thankful for what you have spent time and energy on, in which we as your viewers just get a little bit more perspective. This legit helps us decipher through all the mainstream media, which is heavily polluted. No question, but I would like to note, I think it's fascinating where we have gotten in this technological world. The witness had no clue how the algorithms were coded. He is an expert. I find that very interesting and scary. We got a person saying, yeah, this is solid, but I don't know how it was made. It's like eating a potato chip and seeing the ingredients, saying the ingredients are just trust us. Come on, man. Thank you. And again, happy Thanksgiving, sir, from Watcher45. Very nice comment. Thank you for that, Watcher45. Happy Thanksgiving to you and your family as well. And I agree. I don't ever just trust the government because they say so. Don't know why people do, but they do. Former LEO says, never observed the prosecution address the elements of reckless endangerment. I did not see a state-called expert to testify about the line of fire, and if it did, in fact, endanger McGinnis. Facts are facts and BS is BS. Good one from former LEO. Few more. Transparency says, the prosecution is now alleging that Kyle pointed his rifle at Rosenbaum and Zeminski before he was chased. How does the law on self-defense relate to this allegation? So, he'd have to be justified in using that. You can't just point guns at people. He needs to have an objectively reasonable belief that he's allowed to do that, because the next step is pulling the trigger. That was from Transparency. So we'll see. Lil Mandy says, when you consider that the natural instinct for animals is fight or flight, Kyle's first instinct was to flee. When he was able to flee no more, he fought. He should be acquitted. That's from Lil Mandy. I think you're right about that. Lil Mandy says, acquitted again. Another super question. Edon Tess says, joining late, but I did see your appearance on Megyn Kelly. Great job. I'm a big fan of Megyn Kelly. I really hope it boosts your channel and your voice. Well, thank you, Edon Tess. I was a little bit nervous. I got to be honest about it. I was a little bit like, what am I doing here? This is crazy. But it was a lot of fun. I appreciate the love on that. Kenny1B says, there's a strange red mark that is not the mouse cursor that is on some of the clips, driving me a little crazy. That's my fault there, Kenny1B. I didn't think anybody could see that, but that's me. That's my cursor. I can actually draw on the video. So I'll have to move that out of the way. My apologies. It's probably driving you nuts. There it is. What the hell is that? Sorry. I shouldn't have said anything, should I? Oxford University says, I say, this Binger chap seems like a smart fellow. If he can send us a 43-page resume and learn to pronounce roof in a nice Oxford English accent, we may accept his application. That's from Oxford University. Well, that's nice. So Binger has a future after all. Edon Tess says, at first I thought that some other commenters were being overly critical towards Binger. After all, he has a job to do. But now I watch the line of questioning. This guy is not after justice. He's just playing petty games because he knows his case is junk. Now I think he deserves the criticism. Well, welcome aboard, Edon Tess. We're happy to have you. Have a seat and stick around a while because it's only going to get worse. C. Davis says, Drew Hernandez wanted Binger to read Twitter post from 8/27. It said, quote, turns out the man Kyle Rittenhouse shot and killed last night in Kenosha was Joseph Rosenbaum, a convicted sex offender of sexual misconduct with a minor. Here's the video I shot of him begging to be, quote, shot in front of a gas station minutes before his death. He then posted the video of Rosenbaum and the shoot me N-word incident at the gas station. Ooh, that's interesting. I wonder if that could have gone differently. Like if the defense came back and said, oh, well, you asked him about his Twitter posts, so maybe you opened the door to Twitter posts. How about we read another one of his Twitter posts? Oh, what did you say, Mr. Drew, on August 27, 2020? What did you say after Binger's text message? He asked you about your Twitter post. What did you say on the next one? Oh, Rosenbaum's a convicted sex offender. That would have been clever, but they didn't do that. Okay, a couple others. Talik says, if the guys testifying used levels to brighten, darken, change the contrast before he zoomed the image, that is bad. Levels usually destroy data, cuts out the low end, high end, alters pixels. So if you do this and then zoom the image, you're starting from a really bad point. You've got impartial data, which makes the guesswork the algorithm does less accurate. So it sort of sounds like good data in, good data out, bad data in, bad data out. When you do this, you should zoom, then address contrast. Then the zoom will make its best guess, use the pixels to fill in the difference. So if those are altered, it makes a big difference on the order you do things. There you go. That's a nice comment also, Talix. That makes total sense. You can't put the turkey on before you put the mayo on, right? Maybe that's a bad example. C-Rose says, hey, Rob, I was wondering which of the two defense attorneys had a better courtroom, Chirafisi or Richards. I know they played different roles, but which was more persuasive? I liked Chirafisi much better. I thought he was a much more polished lawyer. Certainly seemed like he had a better command of the practice. Rob Emery says, you answered my question already. I asked it before you got to it. My apologies. When Kyle's acquitted and they riot again, I wonder if more people will come out to protect their property and stand up to this lawlessness. I know a lot of people are wondering what that response looks like, and hopefully it's nothing problematic. Law Medic says the prosecutor was stating that they were going to bring 2 rebuttal witnesses against Kyle, saying that he was not giving his ballistics vest and not enrolled at ASU. What do you believe that will do to the jury? So I'm not sure that we're actually going to see that happen. Jury has already been excused. Those people would have to sort of come back in before Monday, and the judge would have to allow that in. I mean, he certainly could, but are they really going to? Maybe they will. I don't know. I don't think it does anything to the jury. I think it looks petty as hell, which is why it's sort of a stupid thing to do, in my opinion. But okay. D. Delsby, nice comment, says, The prosecution's point in this case is that evidence won't be allowed ever because this defense knows more about the technology and what it does than the state's witness knows. The reality is that the defense's witness knows all of this. Bicubic interpolation is a standard interpolation and takes parameters usually. And if this person is supposed to be an expert in this software, he should know what he's doing, what it means, and how it interpolates the interpolated pixels. If the state wants this kind of evidence in, they should bring an expert who actually understands the process, not some guy who just sits at a computer to play meme lord. The point of their objection here is that their expert doesn't actually know what's happening, and that's the whole point. Their witness could be manipulating the image without actually knowing it. That's the entire point. I really wish Schroeder would have blocked this evidence, but base that on the person manipulating the image, not the potential process of manipulation. Yeah, and that's a great point there, D. Delsby, which the defense could have hammered a little bit harder. You know, it's not that they're claiming that we don't know that it was manipulated. Well, they hit that pretty hard, I guess, but it's a great comment. I appreciate that. Law Medic also says, I was not able to see anything on the images that were enlarged. Did you? It's blurry for me and most people. Do you see it swaying the jury? No, I don't. I don't. I think that it won't because it's probably a pretty accurate portrayal of what was happening there. And everybody saw all of the other video footage and nobody talked about Kyle, pointing the gun. Well, I guess a couple people did. Todd Trout, but I don't think it's consequential. Todd Trout says, Rob, the disputed picture of Kyle holding the gun is simply a Rorschach test. Your bias will dictate what you see. Not reliable information, should not be admissible. I can't even tell if the person in the picture is Kyle. So there you go. It's going to look like a couple of blobs on a screen. ED says, if I were this judge, I might respond, quote, I may not know the newest technology, but I do know the law. And if there's a technology that is interpolating, or other words, making its own decisions on what is there or is not there, that by definition is not admissible because I cannot question the tech on why it added a pixel there and not there. I don't care if this is, quote, the way we do it now, then the legal profession should stop using this tech. It could be manipulated intentionally or unintentionally. Well, you'd be a great judge there, Edon Test. I'd love to be in your courtroom because that's a good answer. Another one says, after what you've said about the government equipment being inaccurate, and if Kyle is found guilty, I'm going to call this the Nuremberg trial. Ugh. We have, it's Jake from Oxford says, it's the Chirafisi dab. Okay, that's a pretty good one too. I like that one. No Doubt says, in spite of how much you may dislike Binger, an honest assessment would rate him as the best lawyer in the room. That is taking into account the arguing of motions to get or prevent evidence in front of the jury and communicating a more effective story to the jury. While Chirafisi is effective on cross, he lacks in other areas. Richards and Krause just make everyone else look good. While the above may sound like a compliment, overall, the prosecution has presented a better defense than the defense, and the defense has presented a better prosecution than the prosecution. This would be a fantastic comedy of idiots if the life of Kyle wasn't in their hands. Well, that's one perspective there, no doubt. I think that, what you're seeing from the prosecutor is sort of a lot of bravado and sort of fake confidence or competence to some degree. But most of the stuff that's coming out of his mouth is pretty much just straight trash. We have John Halgren says, I had to duck out yesterday. Any takers on the Eric's House donation bet? I'm saying the jury reaches a verdict in under $2.45. $20 donation made by the losers out there. So I'm going to take you up on that, John. Anyone else wants to do that, feel free to hop in on that game. 2 hours, 45 minutes. A verdict under that time, you win. Verdict over that time, you lose. If you lose, or you can take the over, right? You can say, I think that like if you wanted to bet John, you would have to take the over. John wants the under. Says it's going to come in at under 245 hours. If it does, John wins. If you take that bet like I'm going to, and it's over 245, then John loses and he's got to pay the $20 over to Eric's house. So if you want to play that game, pair yourselves up. I'll take a couple more. I'll take both sides of this coin. I think that 245 is probably, it's a good one. It's a good number. Ugh, damn it. All right, so we'll have to see. I'll take both sides of the bet because I donate a lot to Eric's house anyway. So I'll take them all day. I'll take a lot of bets if you want them, but because I'm donating it anyways. But it's fun. 2 hours and 45 minutes. That's a good number because that's going to split the middle on that one. D. Delsby also says the prosecution needs 4 hours for closing because they have to make up all the, quote, facts for their case. Takes a lot of time. It's hard to inject nonsense into the ears of the jury like, oh, that thing went from 2 pixels to 400 big pixels on our blown up image. That's a gun, as you can see clearly from our doctored evidence. It's pointing at Zeminski's head here. See? Yeah, you can see it right here. I just got done editing it in Microsoft Paint. Thank you, D. Delsby. Briggs57 says, on the list of things I look forward to, doing more than listening to Binger's closing arguments. Oh, goodness. Says, shaving my man parts with a belt sander is up there, which is just the worst. That sounds terrible. John Halgren says, I feel there's a little chance the jurors stay away from reading about the case. They're human. What if any research has been done into juror behavior when excused like this? I don't know there, John. It's a good question. The problem with that type of research is nobody tells the truth on that stuff. Everybody lies. Kenny 1B says, Tom Cotton. I want to focus on... Tom Cotton say this? If Tom Cotton said something like, Joe Biden called Kyle Rittenhouse a white supremacist. It was really the go-to move of the Democrats. They do that all the time. They don't like that Virginians elected Republicans. They don't like the U.S. Constitution or the norms. They're constantly losing arguments. They're saying it's a sign of a party that is not strong or healthy. That's from Tom Cotton. Calling this young man a white supremacist on the basis of a few seconds of video. It's a nice statement from Tom. Tom Cotton, Senator. Sapper Jackson says, hey, Rob, I'm back from my border mission in Yuma, settled into my new house. That's why I've been gone. But I'm caught up on Kyle now from your breakdowns. Sweet. I noticed in a recent video you asked about Nick Sandman, the boy who sued CNN and others. I have a buddy in my unit that went to church with him. Apparently he won over $500 million. What? CNN was like $250. Same with MSNBC and the others, but he's poised to settle with $750 million. Wow. I hope Kyle sues off Joe Brandon's pants off. That's a lot of money. So I don't know any about that. I think Nick Riccato was telling me about it and said that the first one was NDA'd, right? So that nobody knows what the settlement was for. Sounds like a lot of money, though. Probably a little too much. Captain Jim says, speaking of your 6 days in Arlington doing science, the GC machine was a Shimdazu AOC 5000. Ladies and gentlemen, AOC tested my client samples. There is your reasonable doubt. You're welcome. That's true. It was. I saw that. That's hilarious. I posted pictures about that. Kenny 1B says, Fox News says that Joe Biden called Rittenhouse a white supremacist. Can't even believe how appalling that is. Spokesperson also blasted the media for getting the facts wrong. Former LEO says, I heard that one of the manipulated videos showed Jimmy Hoffa. Okay, a couple others. Corey Chirafisi says, I don't hate him because he is fat. He is fat because I hate him. Okay. No Doubt says, I can't believe the defense never pointed out that Kyle's hand did not come off either the pistol grip or the handguard in the BG on the scene video. Their ignorance of firearms hurt their ability to point out key facts supporting their case. Somebody should take them back out and slap some sense into them, figuratively speaking, of course. Also, can you shed some light on the discussions around talking to the media, how it can waive the right to remain silent? Yeah, so, if you get out there and you start talking about the specifics of the case, then you can be impeached about some of those statements if you come in court and say something differently about those, because you're waiving your rights now. You're waiving your rights, you're taking the stand, and you can now talk about that stuff. You can actually specifically say in that prior interview that you gave, you said something different than you're saying here. Were you lying then or are you lying now? But what the prosecutor was trying to do is, since he was on the stand and waived his issue, he was trying to get into other conversations about his right to silence and about all of those other things, saying that by talking to the media, he waived that right to silence, which is not accurate. So if he would have waived his right to silence, taken the stand, and also given another media interview that had some conversation that was directly on point about the case, he could have been asked about that. But the media interview was not on point. It's a good question, a little bit complicated, but a good one. Jando Boy Lero says, are those impeachment templates still available? I'd like to file articles against Binger. They are, Jando. The impeachment party templates are still available. They're probably still in that pinned post. Vientikis says, not saying that, Vientikis, not going to do it. Former LEO says, when this over Rittenhouse, should get the same attorney that won the judgment against the WAPO, Covington Kid Sandman. I think that was Lynn Wood, though. The attorney would be busy for a year going after everyone who defamed him. I think that was Lynn Wood. D. Delsby says, what are the options that the defense has if Binger makes up evidence or provides interpretations that witnesses didn't provide to the evidence that was up, like the last admitted evidence of the modified pictures captured from the video? I suppose the same question for the prosecutor with the defense fabricating evidence. So if you're in a closing argument and you say something that's not in evidence, there's an objection for that. It's called facts not in evidence. And you just, nobody said that. What do you say? Nobody said that. And you object and you pause and you go back and you look at nobody said that. Jury, disregard that. Nobody said that. Don't say that again. So you can actually object in the closings. All right. Greg Murat says, hey, Rob, if Grosskreutz was shot center mass and not in the arm outside of the testimony, how differently would it play out in the case? I ask because leftists are always insane enough to suggest that police should shoot the legs and not center mass. I think he would have been justified. I mean, I think he still would have been justified. I don't think it would have changed anything. Instead of an attempted intentional homicide, if he would have killed him. But he was justified to shoot. It was about the force that was allowed to be used to stop the threat. It wasn't about ultimately the outcome. The outcome, you're authorized all the way up until death. Now, it didn't happen in that case. If it had, it wouldn't have changed anything. I think you still would have seen the video evidence of the gun coming up, and Rittenhouse would have testified similarly, and the video evidence would have supported it. Kincaid says, if catching someone in the act of finding them guilty requires, quote, the good guys to lie, cheat, and steal, how long will it take to buy their dirty deeds? Just saying, $1.30 per makes a lot of sense. Thank you, Kincaid. We have Rational Gaze also says, Drew Hernandez, I believe, was the one who filmed the video from August 24th of Antifa showing up with assault rifles. Has that video been introduced into evidence? Probably. I mean, there were like 21 videos that made it. Seems like that might be something of a rebuttal to all the wokesters saying, Kyle bought an assault rifle to a protest. That makes him guilty. Yeah, that's a good point. It probably has. I don't know that one specifically. But remember, Binger introduced like 20-something things. Prosecution keeps trying to give a state of mind for the assailants, ignoring what a rational person might do in reaction. It's pretty sick. Bianca says, Corey's face was obviously saying, damn, Big Mac, you got it on my face. Another note, I really felt sad after the defense rested. Feel like they didn't offer much, especially the lack of objections during Kyle's testimony. After you pointed out that they didn't acknowledge him after, I also noticed they left for a while today. Kyle was alone with the prosecutors. Richard seems to have somewhere else to be. You think the defense lacked fighting more for him? You think Kyle still has a good chance? I wish they did more for him. Very sad feeling after they rested. I cried so much when he started crying. Well, that's very sweet, Bianca. You know, you're seeing raw human emotion and you're empathizing with that, and I can relate to that. It's bad bedside manner. I don't think that you're seeing a, creme de la creme of criminal defense attorneys here. A lot of it seems sort of cobbled together. Some of it's sloppy. Some of it feels like it's, a little bit lazy in preparation, but it's a style of practicing law, not mine. I honestly think on this question, if you asked 100 different defense attorneys, you'd probably get 100 different answers on this topic. So, I hesitate to be overly critical, but there is some problems with what I've seen. I mean, a lot of it seems sloppy. When they don't even acknowledge Kyle after 6 hours of testimony, it's like, guys, I know you're tired, but this is the big game. This is the Super Bowl. It's like, put your game face on. Stop slouching in your chairs like, I'm tired, I would just want to go home. They didn't even do a redirect of Kyle Rittenhouse, a redirect of the key witness in the whole case. No redirect? It's nonsense. And there's no reason for that other than he had to go pee. It's ridiculous. Pete Hillsells says, Kenosha area. Kenosha is part of the Chicago metro area. It's the northernmost part of it. It's right between Milwaukee and Chicago. A lot of people from Chicago moved up to Kenosha to get away from taxes, overregulation, and expensive housing. But they retain their Democratic machine attachment. The country is a purple county, pretty evenly divided. The Easter Inn intend, the city near Lake Michigan, is more Democrat. Western Edge is more Republican. Thank you, Pete Hill, for that background. It's good stuff. Sean LVNV, Time Lord Stu, says, while I wasn't particularly happy at Schroeder's ruling, Is this really that devastating when looking at the aggravate? I mean, even today, Washington Post has thrown in the towel on this case, stating the prosecutor has been undercut by his own witnesses, made strategic errors, struggled with inconvenient facts in pressing his case. Probably not. You know, like I said, a lot of this stuff I think is to confuse the issues. It's also red herrings. It's just to get the jurors to latch onto something. Uh-oh. Judge Schrader is here, says, "Don't get brazen with me." Sorry, Judge. Sorry. I won't ask the same question 35 different times and then try to crumple all over people's constitutional rights. All right, couple other questions here. Jay He says, "You did a fantastic job on Kelly. Awesome to see you reach in the big leagues now. Keep up the great work." She is big leagues, isn't she? I don't know what the heck they reached out to me for. I don't know what I was doing on that show, but it was fun. Miles Breeden says, "Any idea why the case went from Linwood to these guys?" Lot of gossip about all those decisions. I have no idea. No idea what happened there. A lot of those attorneys, I think, are in a lot of hot water, a lot of different reasons. Here's where we're at. Davis says, "On the length of the trial, I feel like it will take 30 minutes if everyone is already not guilty. But if there's only one hater, I could see the deliberations going on for several days. From your experience, how fast do deliberations go when everyone agrees?" Fast. Yeah, quickly. Remember what happened in Chauvin? How long were they out for? Like 6 hours? It was like a day? Maybe a day and a half? Very quickly. They all pretty much agreed. Joey Bandolero says, "I just want to say that I don't get why you all don't like Binger. I don't mind him that much. Must just be the faux hawk glasses combo." Pato says, "Binger wouldn't need 2.5 hours if he didn't describe every type of weapon Rosenbaum didn't have. Want to bet on how many times he brings this up in closing?" Too many. A lot. Too many. Former LEO also says, "If you don't intend to take a life, don't shoot. You make the call that it doesn't fit the criteria for deadly force, so you shoot for the legs and clip the femoral artery, and now you end up with a dead suspect with no justification." Yeah, that's the reason why you don't follow Joe Biden's advice and just shoot him in the leg. Locals Group says, "We would like to see the comments YouTube cannot see." Oh, well, sometimes they're comments that... That's a good point. That's a good point. We could probably save those comments. We could probably do spicy comment sections or something like that. It's a good idea there. It's a good idea, Locals Group. You're a pretty sharp bunch over there, aren't you? Yes, you are. Yes, you are. The smartest. Harry B is here, says, "I think Drew's video showed a good example concerning the aggressiveness of the rioters. I only wish he would have used language that sounded less biased. He sounded too supportive of Kyle, then he sounded more irritated than anything." He was certainly irritated, was not happy with the prosecution there at all. Jumpin' Jeff says, "Rob, you are a big league all-star. Maybe even a closer." Well, that's really nice, Jumpin' Jeff. We'll see where it goes. I'm having a lot of fun, and I appreciate all that support out there. All right, we've got some super chats that came in after the fact. We had Brian Paul says, we got that one. Space Cake says, "Absurd for the prosecution to compare blown up pics of rioting when tiny details don't matter to a small amount of pixels in the distance being blown up to show tiny detail, the gun. The judge got conned." That's from Space Cake. The judge got one sort of squeezed by him on that. Not Applicable says, "Doesn't even show anything. It's brainwashing the jury anyways." Bill Cook says, "It's a shame that half the country is uninformed or malevolent and want to hang this kid in the streets. Seems like the video was in because of the mob." Yeah, it might be the case. This guy says, "The defense should have just argued it was too blurry instead of making it into a big to-do. Now it will be more scrutinized more than ever." Yeah, there's a downside to that, right? The jurors might just be confused. Couple others here. Showcasing the guns on the Megyn Kelly show. Congrats. Did I do that? I couldn't even watch it, folks. I didn't even watch it. I haven't even seen it. Aaron says, that was Aaron. RK 2009 says, "Do you think that Chauvin could have humanized himself to the jury if he took the stand like Kyle did? He was made a monster by politicians and media." Yes, he could have, but there was a lot of risk there. Just like there was a lot of risk with Kyle. And Derek Chauvin has a couple more skeletons in his closet than Kyle Rittenhouse did. So a couple other reasons why maybe he didn't take the stand. Pinking says, I would rather eat gas station sushi. I don't even like sushi. Off a toilet than listen to Binger talk for 2.5 hours on Monday. That's pretty bad, but, you know, I understand your point. I mean, that's, on the one hand, you have a toilet gas station sushi. On the other hand, you have Thomas Binger. Yeah, you gotta go with the sushi on that one, no question. A couple others. Latrell Jennings, etc., says, just to clarify, I'm in Kenosha. We're not part of the Chicago metro area, okay? We're on our own. Which I can appreciate that, totally. Totally appreciate that, Latrell. We're not part of Chicago, okay? You leave us out of that. Those Chicagoan people over there, we don't want anything to do with them. Jonathan Himes says, CNN just posted an article talking about the judge's inappropriate joke about Asian food. That's their big takeaway from today. Come on, man. It's true. I saw that. The judge is like, well, hopefully the Asian food got here in time. And they're like, oh, well, that's racist. So this whole trial needs to be thrown out. It goes hand in hand with your American tie and your talk about Roosevelt, you racist white guy. Gravity Music says, Robert should try to pop on Ricada's law stream tomorrow. I may do that. You know, I'm going to actually be traveling tomorrow. I'm going to go out of town for a couple of days for the weekend. And so the show schedule may not happen tomorrow because I might be on the road. We're going to see what happens. I'm going to take a look at what's happening with the trial. I may try to hop on Ricada's stream. I'm going to bring some of my gear to where I'm going so I can continue to stay plugged in a little bit. But I am going to take a little bit of a break since the trial is on arrest tomorrow. Gonna go and hop in the car and go up north for a couple days. So gonna have some fun doing that. But I'm gonna try to stop by Ricada's stream. I just there's so much to say, and it's kind of hard to get a word in on those streams. But man, it's a lot of fun watching them. I'll tell you that. Another one from SysQ says, as a prosecutor, how does Binger not inform himself about how hollow points work? He looks ignorant about how firearms work in a case about firearm use. Yeah, you're right. Nothing else to say about that. He is sort of incompetent in general. 1979 Iceman says 3 super chat attempts. Did mine get missed or not appropriate? So I haven't seen it hit my screen there. I saw that one there, Iceman. I appreciate that. Another one from Zalo Arg says, is it normal for the prosecution to introduce new evidence so late in the trial? No, it's not. You know, there are disclosure requirements. There are different rules about when stuff can come in. I don't know specifically what they are or what was discussed backstage, you know, sort of off the record in a lot of these motions, but it made it in. You know, this was that magic video that landed up on the prosecutor's doorstep, I think on Sunday night, and made it in anyways. Bianca says, thank you so much for the great work. I waited anxiously for your show to start. Emotions are high. I'm glad you can share this time with all of us. Well, thank you, Bianca. That's very nice too. Yeah, you know, my blood pressure after yesterday, the blood pressure and the pulse rate, all the vitals came back down to normal after Kyle kind of got off the stand there. Anytime that you see a defendant take the stand, you kind of, you know, blood pressure goes up a little bit. So he made it through. Latrell Jennings says, all of Kenosha complains about Illinois plates. That's great. That's hysterical. So I love that. Okay. And so that, my friends, was the show for the day. I want to welcome some new people who joined our community over at watchingthewatchers.locals.com, where we are building an amazing community. We've got the Next Unicorn, Official Glyph, DeBiff, Custodes, PNEW, Robert Emery, Chip Von Shoulder in the house, Paralaw, Crime Junkie Jekka, Future Freedom Now, Briggs, Gecko Man, PWS, MKAZ, CPO Forever, and D. Delsby are all in the house, and we had a ton of new signups, and so I gotta add everybody. Thank you so much for coming over and joining us. 2 super chats came in. J Rod says, do you think Kyle will be found not guilty? I do. I really do. I think that it's pretty much a cut and dry case. Hopefully the jury thinks so as well. And also says 1979 Iceman says, my bad. Just want to see your take on how this will affect future self-defense cases if Kyle does not win. So the legal answer is that it really won't. You know, it's only going to be sort of limited to this court, this prosecutor's office. It's not going to be binding precedent anywhere outside of this jurisdiction. So in other words, not going to impact my cases here in Arizona one iota. Now, if this gets appealed or something, Kyle loses, gets convicted, and there's an appeal, and it works its way up to circuit courts, and the Supreme Court comes out and issues a new ruling about self-defense law. Well, now Arizona is under the purview of the Supreme Court, and so it matters. But it's not under the purview of whatever court this is in Kenosha, Wisconsin. So it's not going to sort of leave there, but it's going to have it's going to leave a mark, in the public perception of how self-defense works. It's going to change how prosecutors perceive this. It's going to change how prosecutors think that they can get convictions, that they're going to get jurors who will look at a case like Kyle Rittenhouse and still convict somebody. It's kind of an indicator that the times have changed. And so that's why it's so important. And it's a great question there, Iceman. Thank you for sending that in. I'm glad we got to your question. Sorry if I missed you earlier. And again, watchingthewatchers.locals.com. It's a good place to be. We have monthly meetups. We're going to have one early on in December, but I got to find a date for that. And it's a good time. Come say hello. We put names to faces. And so that, my friends, is it for me for the show for the day. Quick reminder, as I mentioned earlier, I'm going to be traveling tomorrow, so I don't know if I'm going to be able to do a show. It kind of depends on when I get where I'm going and how I can get set up and all of that stuff. But the trial is going to be back for full jury deliberations starting on Monday. Closing arguments, and then we'll get back into trial coverage. Tomorrow is going to be a bunch of jury instruction stuff. It may not even be on live stream. I don't know if they're going to want to do a lot of this on record or not, but I'm going to be available. I'll be checking in with you over at watchingthewatchers.locals.com. I'm going to bring some of my gear up north where I'm going. And so I will very likely be able to post an update over the weekend and check in with all of you and just see how everybody is doing. Latrell says, visit Kenosha, see the lakefront. Beautiful city. I'd like to come check it out. No question about it. And so that, my friends, is it for me for the day. Thank you so much for being a part of the show. If I do not see you tomorrow, have a tremendously amazing weekend. Final shout out to our veterans out there. Thank you for your service to this country. I mean that. Hopefully everybody's having a very nice day in honor of those people who have served us and has a very nice long weekend. A lot of Rittenhouse news, a lot of it. And we're not done yet. We've got a lot more to get to. And so we're going to be back here on Monday, if I don't see you before then, to do it all again. And I don't even know what time it's going to be. There's going to be a verdict, and we're going to be just primed, spring-loaded, and ready to go. That's it for me, my friends. Have a tremendous evening. Sleep very well. I'll see you right back here on the next one. Bye-bye.